The speaker of the day, I-CA.Akash Jain. I thought we'll start sharp at 10, but 5 minutes grace time has been given. Let us start immediately. People can join as they are coming. We'll start off with the motto song.
सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः तदेव शुक्रं ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे ततो नात्यर्य कश्चन एतद्वैता 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 एतद्वैता.
So once again a very good morning to everyone. Welcome to this one-day seminar on FEMA. See, at SIRC what we are trying to do is we are trying to identify practice areas where we need to have more in-depth knowledge to grow our practice. It's always directly proportional, and to also offbeat topics. So in this day and age when where information is abundant and easy to access, the real advantage will be known only when we know where to focus. So this is a niche area of practice, but with the blurring of the borders between the countries, the cross-border transactions, the global economy, this is one of the areas where we need to actually equip ourselves, and also on the back of all the regulators who are looking over our shoulders. It's better that we are a little ahead of the regulators in terms of interpretations, in terms of upskilling, and in terms of actually being ready to face whatever is the queries which are raised to us tomorrow. Because in the day-to-day nitty-gritties of practice, we tend to actually sometimes skim over information which is available and try to just 1 minute and try to actually get the work done and get it out of the way and move on to the next task. And when we are doing this, it's not due to ignorance that we miss something. It may be due to our own preoccupation with our practice. And once we keep upskilling ourselves, listening to various people give their opinions, their experiences in the various practice areas, we also tend to recall, if we don't actually go back to refer, we recall somebody told this, let us have a look at this. So that is the idea of actually doing all these sessions. And today's session in the afternoon by CSTP Sridhar is going to be an extremely interactive session. The ground will be laid by Akash, and Sir will be taking over from there. And please ask all your doubts to him. We did circulate a Google form, and if you have not had the time to give your questions on the Google form, please do interact with him, because he's very experienced in these capital account transactions, and he tells me that a lot of chartered accountants call him, at least 2 chartered accountants a day call him and ask him doubts, and he's willing to clarify all our doubts. So I'll move on to introducing Akash Jain. Akash Jain is a very young chartered accountant who founded one of the firm SARC LLP since April 2022, and he has cleared his diploma in international taxation conducted by I-CA.Akash in the year 2020. And before starting practice, he has worked for 5 years, gaining experience in handling cross-border mergers and acquisitions, FEMA compliances, corporate tax structuring, due diligence and transfer pricing assignments, including cross-border deals involving analysis of international tax laws. And he collectively holds professional experience of a decade in the field of direct taxation, including FEMA. And he has been a part of the due diligence advisory services and has given opinions on MNCs, two MNCs on tax optimizations through restructurings and deal advisories. And he has also advised clients on litigation cases and has also assisted counsels in various assessment cases at the Madras Tribunal level. He is actively involved in taking various sessions on direct taxation to professional firms and collaborates with other professional colleagues to update them regularly on tax matters. And he has taken sessions in various training institutes in latest developments in direct and international taxation. And he has also conducted various career counseling sessions in colleges and schools in mentoring and guiding and inspiring students. So today we have a mix of a senior as well as an upcoming professional, both of them sharing all their experiences and whatever they have acquired on the way. Thank you very much, Akash, for taking you the time to come here. Over to you. Thank you very much.
Okay, a small memento to Akash.
Yes, thank you very much, Revati ma'am, for such a wonderful and energetic introduction. So, first of all, I would like to thank the institute for setting up these kind of programs, whereby it's an honor to come here and speak amongst the professional chartered accountants, and with this we also try to always have updation of the knowledge and always keep reading, so that we also ensure that whatever we are delivering is up to date and amended law, right? So thank you very much, ma'am, and thank you, institute. So we'll start, as ma'am rightly mentioned. What we'll be doing is, first, in the first session, in the first half, just switch off please. So in the first half, we'll be focusing on the basic provisions of FEMA, setting the standard of and getting the basic understanding of interpretation of FEMA. What are the various areas in this FEMA which requires our own interpretation, and which is very litigated in the terms of the FEMA practice, right? So that I'll just brief you in that aspect, and then in the second half, Sridhar sir, he'll be taking on the doubts and the practical experiences on the FEMA, right? So we'll just start. First, I would like to thank Ishan for helping me out to put this PPT up. So he's right here. So thanks, Ishan. So first, we'll understand how this FEMA evolved. Okay. So if you look at the FEMA regulations, the first which was introduced during the independence era, it was like FERA, Foreign Exchange Regulation Act. So that act concentrated on regulating the foreign exchanges. It never gave a positive news towards liberalization, or it did not help us to extend our arms, the Indian arms, right? So it was more restrictive. It was more towards like the money should not go outside India and it should be in a regulated and restrictive way. But post 1999, that is, we call it as the post liberalization era, the FEMA was introduced, whereby the motive of the government completely changed. They wanted to let the Indian arms or the Indian entities move outside India and then come out with the solutions whereby they get into the field of the global practices, okay, for which a lot of changes were made from the FERA Act to the FEMA Act. If you look at the interpretation of the FERA and FEMA also, you will get to know that basic, the preamble of the Act itself, tells that. So before looking at the preamble and these differences, we would like to see what causes us to read this FEMA, okay? Why this FEMA? So even if you look at when I was doing my CA finals, the FEMA was merely a 4-mark question in the final examination. So we always have that tendency to skip this. Let's not focus on this word. Let us focus on the balance 96 and get it through. But when we actually came into the practice and saw the field of FEMA, the opportunities are huge because the transactions involved, the money involved, okay, the entities involved, and the global MNCs having their own interest in India is bringing up this FEMA practice into more and more, in a more positive way. Okay, so this is very evident with some statistics which I wanted to portray. First is if you look at the FDI inflows which is coming into India, right? Recently, it has been the last financial year. It has been approximately $17.96 billion. Okay, which is among the most highest FDI inflows in any of the countries. So if you look at the countries from which the FDI inflows are coming, first is the Mauritius. Okay, Mauritius is 37%, Singapore being 32%. Because these countries, they have very less foreign exchange regulations, provisions. If you look at Singapore, it does not have any foreign exchange regulations. It involves a mere, reporting of the foreign exchange transactions what we are doing. So that's why you can see major transactions are happening from these countries. So whereby India is also moving towards that. So now recently when, before the oath taking ceremony also, Mr. Modi also mentioned this point that he wants to ensure that government is not involved in the common people. He wants to ensure that the less the government intervention, the more happier the people will be in terms of regulations. And as a professionals, we have known that the recent amendments which has come, including any of the law, if you look at, the basic thing is the GST aspect also. The everyday changes it's happening, and it's kind of the regulations which is more restricting the ease of doing businesses. So even recently, my experience also says that some non-residents with whom we are transacting and are our clients, they also have this tendency of they're having a restriction to invest in India. It is because of the lack of ease of doing business. So let us hope for the best in this coming government. So if you look at the countries, right? So these countries bring in the most FDI inflows in India. Now, which are the states which received the highest FDI inflows? Which is in the last year. So Maharashtra, Karnataka, Gujarat being always the top 3. Okay. Tamil Nadu is also in the top 5. Okay. So now even Tamil Nadu government is having this more and more state policies coming in, which giving liberalization and more incentives to the foreign entities, right? So Tamil Nadu is also getting a good traction. So you can understand with this amount of money involved, $17.96 billion, how much the scope which is available under this FEMA regulations, right? If you see the year-wise FDI inflows in infrastructure, this thing itself, up to December 2023, it was 10.56, it has moved up to almost around 15, okay, in the current year. So this is also, now this is with regard to the FDI. Even Indian arms are going, and investing outside India, overseas. So if you look at that amount, right, the amount involved, every year on year, it is approximately $17,858 million. Okay, so that is also a very good number to come out. In April 2024 itself, it is approximately 2804. So the numbers are increasing, and it is showing a tendency of opportunities, various opportunities available, right? So this is the sector-wise which I have given a breakup of the ODI, where most of the ODIs are going. This is also very important because unlike any other law, FEMA law does not give a blanket provisions for all the sectors. Okay, it has performance linked indicators or conditions whereby what happens is if once you need to invest in a particular sector, right? So those conditions of those particular sectors are applicable. So that's why reading the FEMA law from the angle of the industry or the sector in which you are going to invest or where the investment is coming is very important. So that's why these numbers also give us a good overview on what exactly and which sector is booming. So now the difference between the FERA Act and the FEMA Act. So as I was mentioning, if you look at the preamble of FERA Act, right, it says an act to consolidate and amend the law regulating certain payments dealing in foreign exchange and securities transactions indirectly affecting foreign exchange and the import and export of the currency for the conversion of the foreign exchange resource. So basically here they talk about the regulation, regulating aspects and all those things. Now if you look at the FEMA's preamble, it typically states that it is an act to consolidate and amend the law for foreign exchange transactions. It aims to facilitate external trade and payments. It aims to facilitate external trade and payments and promote the orderly development and maintenance of the foreign exchange market. So this is what the main differences and the intention of the government has changed when the FEMA was introduced in 1999.
One question here. Would it be because India is supposed to have very healthy forex reserves? FEMA would also be one of the reasons for that.
Sorry?
So India has very good foreign exchange reserves. I must be around, I don't remember the exact numbers, it must be more than $600 billion or something.
Correct.
So could it be, one of the reasons could it be FEMA as well? Because there are a lot of liberalizations that have taken place.
Yes, so as you rightly mentioned, this foreign reserves is increased on a yearly basis. Okay, so now it's the recent number which you are telling us, that's around $600 billion. So that is one of the important aspects to regulate the FEMA. Okay, if these regulations are not available, India will not be able to have the base of the foreign exchange, right? So that is the base. So keeping that as the base and the regulation aspects, this helps a lot in terms of framing the law and then interpreting it, how to take it forward. Now if you have a good foreign reserve, right, so that also have a great indication that the foreign investments are coming in India. So the trust is getting built in the Indian Development Act. So that is a very good indication which we can take it to. So now if you look at FEMA if you look at any other law, right, Income Tax Act or the GST Act, it has only one or two regulators, okay, but FEMA is not that way. The main, the body which regulates the act and which gives a lot of insights is the RBI. Okay, RBI brings out a lot of amendments, notifications, press releases, okay, master directions and all those things. But with RBI, if you also look at the Finance Ministry, it also issues the notifications which is applicable for the FEMA. Okay, DPIIT, it gives the industrial policies and approval. So, lot of aspects you can see in lot of the places, RBI, where they are framing the acts and rules, gives indication that for this particular industry or for this particular setup or structure of the company, if there is any approval of industrial policy which is already available, then in that case these conditions are satisfied and the FDI or ODI or vice versa is allowed. So it is very important to read those act, rules, regulations with these administrative or regulatory authorities. There is also CCEA, okay. Ministries also give. Then a very important aspect, ED, which we will be seeing at the end of our presentation. ED has become one of the more active in the recent times because of the obvious reasons. So what exactly we can take from the administrative aspect of ED are the orders. Either you look at the orders or the penalty orders or what is the interpretation or how they are reading the law and interpreting the law is very important aspect. So this is given, this particular ED authorities, we consider this as one of the last authority, but actually if we go from the reverse angle, right, ED order issuing orders, RBI issuing orders, those orders if you look at and go from the reverse angle, you will understand that what is the interpretation of the authorities and why they are coming out with this. Because FEMA is, we also call in our language, FEMA is a very clumsy law, okay? It is not a structured law. You cannot open the RBI page directly and see, okay, FEMA, all the amendments will be there, so just download the PDF and do it. It's not like an Income Tax Act. FEMA, now it's much better. Now you can find everything online. But when I was doing my articleship, my principal used to tell me that when he was practicing FEMA, he used to go to the RBI, get the printout of, big printouts of the law, big printouts of that official gazette where the amendments has to come. He has to sit, read and then interpret, okay, this law is there, but yesterday one more notification has come which has amended this law. But there is no link between yesterday's notification and the act or law which is already available. So this is the level where the FEMA plays a role. You have to be updated in all the angles and you don't know from where you can get the updation. So from all these ministries or authorities, it is always better to have an updated knowledge whether anything is affecting the FEMA regulations or not.
What is the difference when you go back to the previous slide? You were saying the CCEA, that is Cabinet Committee on External Affairs, has specified limits approval and ministries have specific approvals. What is the difference here?
Sorry?
What is the difference between the specified limits approval and what is specific approval? You are saying CCA has specified limits approval and ministry has specific approvals. What is the difference here?
See, so what happens is CCEA comes out with a specific approval for an upper cap, the limit of the cap, so that you cannot.
It's only a monetary limit.
Yeah, mostly it is a monetary limit, but ministries come with specific approvals in terms of you cannot invest in a real estate activity or you cannot invest in a financial service activity unless you are also one of the NBFC or through approval of the RBI. So that is the difference which generally happens. Now, as we were discussing what to read under FEMA and what are the basic things which we have to see. One is the FEMA Act, which has almost around 49 sections, okay. The rules are there, there's only 8 plus rules. So if you just read the Act and rules, you will see that it is a very small Act. It is not even covering more than 60 plus sections or rules. But there are certain regulations, okay, which keeps on changing, which keeps on coming or additions are there. So currently there are 25 plus regulations which are issued by the RBI, okay. Then after that also you have something called as circulars, okay. Then you have master directions. Then you have government policies for FDI and press notes or press releases. Then very important, it is like FAQs and press release. It is not like our income tax FAQs where you will see, okay, what is applicable and what is not applicable. These FAQs are binding on the authorized bankers, okay. So based on the FAQ, you can very well interpret the law and you can take a decision on whether to invest or not. So that is the importance of FAQs which is there in the RBI FEMA. Now this is the
what is the difference between press note and press release?
See, generally what happens is press release is in an official gazette or an official document whereby it is released from the government side, okay, in an official gazette. But if you see the press note, it is normally a directions which is given by the RBI to their authorities, okay. These directions are also available online and we can also have a view of it. So if any direction is given by the RBI to the authorized bankers, we are liable to tell the bankers that this is based on this particular direction or press note, whereby you are required to act in a certain way, because sometimes due to lack of the knowledge, bankers will ask us a lot of documents which is actually not required. For example, if you see for investing in ODI, right, when a resident individual invests in ODI, prior to 2013 it was not allowed. But bankers used to do that because of the lack of the knowledge and interpretation issues, because of which a lot of clients also face the issue. But after that, a notification came which clearly said that if a resident individual wants to invest in this way, bankers has to clearly get an NTT KYC 6.2 KYC from the clients, right? So that 6.2 KYC has come from the press note that has been issued by the RBI to the bankers. So these are the basic internal documents which we can call it as. So there is no much difference between the press note and press release in terms of the applicability or implications as such, but it is an internal as well as an external document.
Normally when a press note is issued, the earlier one gets decided, or it also
no, it depends, sir. So normally what happens is, if any of the press note or press release is issued, if it is amending a previous one, it will for sure tell that the press note release or the press issue release, that is getting notified, and then that is getting amended and the new one is getting notified. But still the old one will also be available. So if you're not updated with the new one, you will have an impact that you can take a decision based on the old press note also. So this is how the FEMA RBI Act website looks. Okay. So if you look at here, you will find notifications, press releases, speeches and media interactions, publications, legal framework, research, statistics, regulatory reporting. Okay. So this is very important because if you look at the official website of the RBI itself, it is in the first page itself. It gives a hint that any of the document which is having any of the implication on the FEMA can be applied, and the interpretation can be made in such a way. Now, with this difference in FEMA and FERA and why this FEMA has come, now we'll move to some of the basic principles of FEMA and the understanding of the definition, right? So first is to whom it is applicable. Okay, when we talk about FEMA, whether it's applicable to everyone or to whom it is applicable, right? So it says whether a person is a resident or non-resident, doesn't matter, and whether a transaction is a current account or a capital account transaction, it does not matter. It is applicable if there is a transaction dealing between two residents, unless an overseas transaction, right? So transaction between two non-residents, unless it is an Indian transaction. So only in these two scenarios it is not applicable. That means if there is a transaction between two residents which is a domestic transaction, or a transaction between two non-residents which is not a domestic transaction, then only FEMA is not applicable, or else in all the cases FEMA is applicable. Now this is the basic structure of the FEMA Act, how it is given. It is more common like how we read any other law. So the definition section comes in section 2, and after that it starts dealing in. So basically the residential status of the person is also defined in section 2. Then you have current account and capital account transaction. Then you directly come and jump on the export and goods services. Then you see a realization repatriation of foreign exchange. So basically this is, if you look at the structure itself, you will find that there is no flow coming in the structure. So here they are starting with current account transaction. In section 6 they are talking about the capital account transaction, and then suddenly they are starting with the export of goods and services transaction, right? So that means there is no flow. It is just an the act is given or the law is given. So we need to interpret in a way that if in case whichever law or act is applicable, we need to find that particular section, and then what is the corresponding rule and regulation to it, and then we have to accordingly interpret the law based on the the preamble of the act, right? Now if you look at the important definition of FEMA, which is the residential status. How will you determine the residential status of a person? Okay, it is more into, the definition of number of days is just like our income tax act. How it says, if a person is residing in India for more than 182 days during the course of the preceding previous year. Okay, it's not on the previous year; it is the preceding previous year. So preceding financial year, then he will be regarded as a resident in India. But here, one key takeaway is it's not only on the quantifying the number of days, but it is also talking about the quality aspect. That is the person who is not staying for 182 days also can be a resident. But in what scenario? Okay, or a person who is going outside India, even after staying 182 days in the preceding previous year in India, still he can be a non-resident or a person resident outside India as per the FEMA provision. So what are the conditions? A person who has gone out of India or who stays outside India in either case, that is, for taking up employment outside India, or carrying on outside India business or vocation, okay, or for any other purpose where his intention to stay outside India for an uncertain period. So the wordings here itself clearly says that intention to stay outside India for an uncertain period. So that means here itself in the first section of section 2 itself an interpretation has already come. How will you determine what is the intention? How will you determine how is an uncertain period, right? Here in this scenario, one of the basic and most common example was students going outside India abroad, for which a notification has come clarifying by the RBI that if a student who is going outside India, he will not only be a student, most of the time he also be a part-time worker or doing sometime part-time job also. In that scenario where he is a student, he is going for a course and then he is also doing a job and he is having an intention to stay outside India, because of which also he is doing that job, then he will also fall in the bracket of this list, and he will not be regarded as a person resident in India. So that is what interpretation and experiences of the FEMA Act which has dwelled and come into this stage. Now if you look at person who has come out to stay in India in either case, otherwise than for taking up an employment in India or for carrying on an India business or for any other purpose where his intention to stay in India is for an uncertain period. If these conditions are satisfied, even though he has not stayed for 182 days or more in the preceding previous year, still he will be regarded as a person resident in India. So that is the take from this particular interpretation. Now,
he said preceding financial year.
Yeah.
Suppose if they want to return to the resident status for current year, that is 24-25, I should take 22-23, not 23-24, correct?
no, 24-25 years you need to take 23-24.
24. Okay. You were saying previous year.
No, preceding financial year. So the financial year for which you are interpreting before that. So the previous year. But these conditions you need to look at for the current year.
Current year.
Yeah, current year, 24-25. Like let's say if you have come to India for the stay in the current year, 24-25, for a business or a profession, okay, or where the intention is not clear in terms of his certainty in the terms of his stay, then in that case he will be still regarded as a person resident in India, even though he has not stayed in the preceding previous year for more than 180 years. So the definition of person resident outside India is very clear, means a person who is not a resident in India. It's very clear. So if he is falling under this bracket, then not an issue. If he is not falling under bracket, then it means he is a person resident outside India. So if you look at the FEMA Act defines only these two the definitions, that is person resident in India, person resident outside India. There is no definition given under the FEMA Act for a non-resident. So NRI or OCI or a PIO, okay, where a person of Indian origin. There is no definition as such given. But there are various rules and regulations which clearly tells that how to interpret or from where this connotation to be taken in terms of the definition of NRI, PIO or OCI, right? So now if you look at the residential status, as we were discussing, a special relief is provided for students by the RBI whereby they can be considered as non-resident due to the stay in abroad and intention to stay for an uncertain period. Okay. In this scenario also they were allowed to take remittances under the LRS. Okay. And up to $1 million out of the balance of their own accounts. So this is the the pointers from the notification which came from the RBI. Now here the main crux is still this is not clear, where cash should be taken in cases where students leave India for short duration courses. What about a certification course if someone is going outside India, or for like let's say 1 year period whereby he is going to come back within India? Still here the clarity is not available. It is still a litigative issue, so we need to be very careful in taking a stand that whether he is a non-resident or a resident in India or not. Right? Now,
Excuse me. A student goes for a study for 3 years course, okay? That is this one. And then it so happened that he is there for 3 years. Will he be able to transfer from his account under loans in the next year when he was in US? Because he will be a non-resident by that time?
no sir, here, so you mean to say?
No.
Yeah. So basically, you are asking that from Indian account he is going to transfer to outside India, right?
Yeah.
That is anyhow allowed, no? Even though under LRS it is anyhow allowed.
But he's not a resident. A resident is allowed under loans, but he becomes a non-resident in the first year itself.
That's fine, sir. RBI notification clearly says that it is still allowed under LRS Act. So you can very well transfer. So now, what happens if there is a change in the residential status? Okay, so there is very good condition here, which says that if there is any change in the residential status, you need to change everything else also. What? A bank account. If you have opened any non-resident bank account, you need to compulsory change in your resident bank account. Okay, where specific timelines will be given. Some are 30 days, some are 60 days, according to the account and the structure. Then if there is any investment in India, okay, let's say if you are having any investment in India because you are going outside India, then section 6.4 and 6.5 clearly says that in case you have invested in India in any of the property, immovable property or securities, okay, then you are very well allowed to hold that, even though after you change the residential status. So that is not a problem. So in case if any other investments are there which does not cover in that section 6.4 or 6.5, then in that case you need to change that investment or maybe transfer or dilute that investment also. A very classic example was individuals in 2013 where the resident individuals were having that ODI investment, right? Because of the lack of knowledge. After which Schedule 5 came, whereby RBI gave clear indications that if individuals are allowed to invest only in this, what RBI brought is, it was our interpretation, okay, as a clarificatory nature and not as an amendment, okay. They clarified saying that from the starting, we are of this view only that ODI investment for the resident individuals is applicable only in Schedule 5 scenarios. So that means whoever has invested previously, even though he was not aware or he did not fall under this bracket, he is now coming under the the scope of a negative assessee in terms of, or a default assessee in default for the particular RBI notification, because RBI told that it is a clarificatory nature that whatever investments resident individual has done, it could be allowed only under this scenario, right? So that one particular notification created a chaos, and then lot of compounding orders you can also find whereby RBI is given because of the lack of knowledge and first mistake by the resident individuals. The compounding is being done and penalties levied for a very minimum amount because of these. The industry itself was not having knowledge on whether resident individuals can invest or not. So in that scenario, whatever investments they have made, they have clearly told that if any investments are made which is not in terms of the Schedule 5, it should be compulsorily diluted or disinvested. So that is the notification itself clearly says. So you need to be very careful that in case if there is any change in the residential status, it is very much important to see if any investments are allowed on the basis of the new residential status, whatever you have gained, whether it's a resident in India or non-resident in India. It is always not deemed that whatever you have done previously, it is always allowed. So that is not a, that is not always deemed. So continuation as partner or proprietor, so that is allowed, okay. As a director or trustee, that is also allowed. So loans given in India or loans obtained in India, that is also allowed. So you no need to, on a basic overview, it says no need to disinvest or no need to change that particular transaction. The same applies for non-resident to resident also. Here one important aspect is when a non-resident is becoming a resident, whatever investments he had already in outside India, that is allowed to be taken care as a resident only. Okay, so no need to again fall back and report to the RBI for all other scenarios. Now this is the basic structure of what are the different bank accounts a person resident outside India and a person resident in India can open. Okay, so NRIs or OCAs, if you look at, if they want to open in an INR account, NRE and NRO account is allowed. In a foreign currency, it is FCNRB account. The same way, if a person resident outside India is including a foreign national, that means NRI, OCI or other than NRI, OCI also. For their personal use, they can open an NRO account, and for the business use, generally people use escrow account or an SNRR account. Okay, this is a special account for this particular person resident. Person resident in India, if he is returning Indians, he can still have an RFC account. Okay, he can open an RFC account, and then he can still have all the investments and whatever is there outside India to be credited to this particular account. Okay. And then resident Indians as such, RFC D account is there, and EFC account EDA, okay, which is also a special account which is given for doing any transactions outside India. So this is the basic of the bank account what people can open. So here also it's very important.
What is PROA? What is PRI?
Sorry?
PROA and what is PRI?
Sorry, person resident outside India, person resident in India. So generally this is very important because if you look at, bankers will not come and tell you, boss, you have changed your residency status, so change your account. Okay, it is us as a consultant or as a client, we need to be aware that if we have changed the particular residential status or this is not allowed, then in that case we need to be very careful in terms of changing the bank account also and intimating to the bankers from suo motu. Okay, so that is very important. So that's why the structure of the bank account, which bank account is applicable and who can open the bank account is very important. Now there are certain more important definitions which is there in the FEMA Act. Okay, so I'll take you through the current account transactions. Okay, the basic of the current account transactions and why there is a difference between current account transaction and capital account transaction. So that is very much important because if you look at current account transaction, it is a day-to-day event or a day-to-day transaction whereby generally the permission is given by the RBI. Okay, we no need to go and check for general permission unless and until it is prohibited. Whereas capital account transaction is prohibited unless and until it is given a specific permission by the RBI. So that is the major difference. So when you read a particular transaction you need to be aware that whether it's a current account or a capital account transaction. If it is a current account, then you need to look at the negative list, whether it is not allowed. If it is a capital account transaction, you need to look at the positive whether it is allowed or not. So that is the.
Could you please elaborate the current account and capital account?
Yes. I'm going to. I'll one by one I'll do it. So this is the basic of why current account transaction, capital account transaction definition is required to be read. Okay. So now if you look at section 2J of the current of the FEMA Act, right, it gives a definition of the current account transaction. That means any transaction, such transaction includes, it is an inclusive definition which says payments due in connection to foreign trade, other current businesses, services and other short-term banking facilities in the ordinary course of business, right? Payments due as interest on loans and as net income from investments. Remittances for living expenses of parents, spouse, children residing abroad. Expenses in connection with foreign travel, education, medical care of parents, spouse and children. So if you look at the list also clearly specifies what are the different types of current account transaction, and it's a very exhaustive list. Current account transactions are freely permitted unless it is prohibited. They are regulated by the central government and the same is discussed in the upcoming paragraph, like what are the different current account transactions. So as per section 5, it says any person may sell or draw foreign exchange to or from an authorized person if such sale or drawal is a current account transaction, provided that the central government may in public interest and in consultation with the RBI impose reasonable restrictions on those current account transactions also. Okay, so the law itself clearly says. Now if you look at the rule, okay, which says which schedule to be read, okay, for what purpose, because there are different schedules which says what is the limit of the current account transaction, where what you can transact, or whether any current account transaction is prohibited or requires a special approval, right? So it says there are totally 3 schedules. One is schedule 1 which says transactions which are prohibited. Schedule 2 says transactions which require prior approval of the central government, and schedule 3 which says transaction which require prior approval of the RBI only if the limits is exceeded. Okay, so this is very common. Schedule 3, if you look at the schedule 3 is very common because a lot of our LRS transactions happen through that schedule 3 list. Okay, let's say gift or investment, sending money to our relatives or for medical purpose, for studies abroad and all those things. Now if you look at the schedule,
even if you spend on international credit cards also it's coming under LRS.
Yes, I have one slide for that, sir. I'll just guide you through. So, the summary of it is currently international transactions are coming under the LRS bracket because that section 7 itself is omitted from the act, which was there. Which omitted it from the act. Then again, the notification came which says that that particular amendment or omission was stopped. So, section 7 is still there, but for the purpose of TCS from our income tax, that 20%, it says this particular international tax credit card is it is under the bracket of LR. That means within the 7 lakhs limit, still this international credit card spendings can be done without the TCS provisions coming into picture. But if you look at the act, international credit cards which is done outside India is not under the LRs. Only for the purpose of TCS, 20% it was there. I'll come to that slide. So some of the transactions which are prohibited, lottery incomes, racings, credit, lottery tickets, okay. Then you have remittance of dividend by any company to which the requirement of dividend balancing is applicable. These are some of the this thing. Then payment of commission on exports made towards equity investment in joint venture, wholly subsidiary abroad, okay. This is also specifically prohibited. Callback services of telephones, okay. This is also specifically prohibited because still a lot of developments also are coming in this particular area of practice. Remittance of interest income on funds held in the NRE non-resident special rupee scheme account, okay. Now if you look at the schedule 2,
third one.
Sorry.
Payment of commission.
Payment of commission?
Payment of commission
on export made towards equity instrument. Let's say if you are investing any of the equity, okay, so that particular made towards, for example, let's say you have invested something and you are exporting also to that particular company, right? For that purpose, whatever commissions you are paying outside India, that is specifically prohibited. So any investment which you have made, for which you are also doing the exports, or for that particular export purpose, the the commission which you are paying, so that is specifically prohibited. Schedule 2.
Anybody or
anybody?
Sorry?
Anybody. It's anybody or subsidiary?
No, the investment in joint ventures or wholly owned subsidiary abroad.
No. If your beneficiary, if your payee is the subsidiary or JV company, or is it prohibited for anyone else as well?
No, anyone else.
Anyone
Yes.
else.
So I cannot pass the credit note or something to my subsidiary.
Yes, no. That's not. So it is generally it is prohibited. So
Suppose
any
I export for under rupees.
Ah.
Tomorrow I find I want to pass credit note to my subsidiary.
No, that is a third party transaction. But this export specifically is for investments which are doing outside India.
Yeah, I invested in my subsidiary.
No. This export they say if you are investing which is there outside India, okay. This is also regarded as an export where you are doing any investment outside India. For this particular purpose, if you are paying any commission as an export, because this particular transaction is also an investment outside India which is regarded as an export. For this particular transaction, if you are doing any payment for the purpose of commission, that is not allowed. That is prohibited.
No, his question is not that. Commission is separate. Suppose if I am giving a credit note because of pricing difference or quality difference, is that allowed?
Yeah, that is allowed. That is a general business transaction which is allowed. That is allowed. So now Schedule 2 which talks about transaction which require prior approval of the central government. Okay. Some of the remittances which belongs to like cultural tours, advertisement in print media, okay, for the purpose of promotion of tourism, freight vessels, freight of vessel charter. So these are the lists which specifically requires an approval from the central government is given in Schedule 2. So I have just noted down the list, and then the Schedule 3 is that which says generally it is allowed. Okay, here only the concept of LRS also falls where they say whatever is the transaction which you are doing, okay, if it is within the limit of now currently the limit is 2,50,000 USD. If it is within the limit of the LRS, it is generally allowed. Okay, so the transactions are coming in schedule like private visits to any country, gift or donation, going abroad for employment, immigrations, maintenance of close relatives abroad, travel expenses, expenses in connection with medical treatment, any studies abroad, or any other current account transaction. So if any other current account transaction which is not falling under Schedule 1 or 2 bracket, then it will automatically fall in Schedule 3, and if it is within the LRS limit, it is generally allowed. If it is beyond the LRS limit, then you need to take a specific permission from the RBI. So Schedule 3 talks about if any transaction requires specific approval of the RBI because the LRS limit is getting crossed.
No, does your clause 9 also cover, suppose if I want to invest in a foreign securities listed in a overseas stock exchange, is it also covered here or it is a separate transaction?
No, that is covered under the Overseas Investment Rules 2022. It will, if you want to invest in any of the equity or anything, right?
In a overseas stock exchange.
Overseas stock exchange. So basically, it is covered under Overseas Investment Rules, which says ODI investment. So if you are investing within the, I mean, it has given the definition of ODI as well as OPI. Okay, what is an overseas direct investment? What is an overseas portfolio investment? So it says if you are investing in any of the listed companies, right, which is less than the 10%, it is very well allowed in the LRS limit itself.
Okay.
So if it is going beyond the 10%, then you have to follow the ODI. I mean, follow the ODI bracket and all. But any investment in unlisted company is directly coming under the ODI aspect. Overseas direct.
That is a specific
Yes.
permission is required.
No, yes, no, it's not permission. It's a reporting requirement. So you need to fill the form ODI and then form FC now. If you fill the form FC and file it through the AD bankers, which will go to the RBI for general approval. It's not a specific approval, it's a general reporting requirement.
Excuse me, one parallel question. I'm not investing in any other company, but I'm putting a subsidiary overseas and making an investment under that, which is allowed.
You're not making fund investments.
I'm not making an investment in any other company. I am floating a subsidiary to do a business in overseas.
How are you floating subsidiaries?
I'm going to do some job work overseas. I'm floating a independent company, not a subsidiary of my company. But I am an individual here proprietor.
Okay.
But I'm going to overseas and they say that the corporate has to be established. Okay. So I'm establishing a company for which I am transferring my capital from here. All my family members are transferring under lumps.
Correct, sir. This also falls into ODI because now resident individual also is coming under the bracket of Schedule 3.
It's not covered as
No, this is under LRS. This is ODI investment. So
ODI, they say it's only under lumps. Again, they say only limited exchange transfer only you can make it.
that was there in the previous law, which got amended
No,
now.
it's mentioned only in 2022.
Yes, Overseas Investment Regulations 2020, in which it is coming under the Schedule 3. So even more than 250,000 USD is also allowed with the proper
reporting.
Yes. So now, this is like the continuation of the Schedule 3 itself. So So we were here. So it says expenses in connection with medical treatment abroad, anything studies abroad, and any other capital current account transaction also up to the LRS limit is generally allowed. Okay. So now coming to the one of the important aspects where it says donation exceeding 1% of the foreign exchange earnings during the previous year or preceding financial year, right? So the following list of transactions will specifically require RBI's approval if it is exceeding the limit of USD 50 lakhs here, whichever is less. I mean. USD 50 lakhs or whichever is less of the following scenario. So these are some of the conditions which is given for specific part of the investment which is going to be made. Now coming to the which we were discussing on the credit card aspect. So I'll just read what was there in the Act previously and then what is come as an amendment here. So if you look at the Finance Act 2020, it says TCS at the rate of 5% for any foreign remittances beyond the LRS limit is applicable. Now what Finance Act 2023 has done, it has increased the TCS limit from 5% to 20%. Now here the question was whether any spendings of the international credit card, right, whether that is allowed as a, whether on that particular spendings, whether TCS is applicable or not. So firstly, the central government made an amendment to that FEMA CAT rules 2006, wherein Rule 7 was omitted, okay. That omission created a scenario that any international credit card spending which you are doing outside India, not from India, any international credit card spending which you are doing outside India, that also falls under the bracket of LRS. Now, if this falls under the bracket of LRS, then as per the TCS amendment of 2023, anything which is beyond LRS, 20% TCS will be applicable. Okay. I mean anything which is beyond the amount of the 2,50,000 USD. So here, this was one of the talks between the bankers and the RBI and the fraternity also, which told that in this scenario, because international credit card spendings are there, which we cannot track it, and how will you note that what is to be paid and who is going to pay and all. But the government was very strict, telling that no, if you are doing any spendings, it will be covered under the law. So what happened, because of all these talks going on between the government and the fraternity, on 16th May 2023, they came out with a clarification saying that this particular amendment will be kept on hold unless the talks between the bankers will go. So currently, as on date, any spending for international credit cards, whether it is not falling under LRS, will be a question. Okay. So what happens currently? That particular omission which was there as under the CAT rules, saying that international credit card spending will be a separate thing and not under the LRS, has been removed. So now what has happened? Section 7, that Rule 7 is still applicable. That means international credit card is a separate transaction and it is not falling under the bracket of LRS as on today's date. That's why the clarification clearly says unless and until the bankers and the government comes to a conclusion on what is to be done for international credit card spendings which is done outside India, then still on all those transactions up to 7 lakhs TCS will not be applicable. But if it is beyond 7 lakhs, then TCS will be applicable for 20%. Just imagine if this amendment would have come whereby they would have removed this particular rule from ICC, okay, and it would have fallen under the bracket of LRS limit itself. Then TCS would have been applicable from the very first rupee itself. Okay, so now they have given a clarification saying that no, you can keep it as a separate rule, but the 20% TCS will be applicable only when you spend beyond 7 lakhs of, only beyond if you spend an LRS limit of INR of 7 lakhs rupees. Okay, so that is the limit which is given from the TCS angle for the system. Now, so there are certain, so this is a summary of what we have already discussed. Okay, remittances by gift donation up to 2,50,000 USD under the LRS scheme, it is generally allowed, and this is the limit which is there. So if you are crossing beyond the limit, then you need to take specific permission from the RBI. Okay. Now, yes. So this is another important aspect. So as we were mentioning, the definition of NRI, PIO and OCI is not given under the Act. Okay. So from where we have to take the connotation of this particular definition and how to interpret this definition and why interpretation is required. Okay. So that is very important. If you look at the, there are various regulations, there's some deposit regulations or borrowing and lending regulations. debt instrument regulation, which indirectly gives the hint of the definition of for a non-resident as per the FEMA. It says non-resident means any person resident outside India who is a citizen of India. So he will be a non-resident Indian. So it makes sense also. If any person who is staying outside India or a person resident outside India and he is a citizen of India, then it will make sense that okay, this person is a non-resident Indian. Okay? So this particular definition is only given in a lot of regulations which are there in the FEMA. Now, if you look at the definition of person of Indian origin, means a person resident outside India who is a citizen of any country, okay, other than Bangladesh or Pakistan or such other country as may be specified by the central government, satisfying the following conditions. Who was a citizen of India by virtue of the constitution, who belonged to a territory that became part of the India after the independence, who is a child or a grandchild or a great-grandchild of a citizen of India. This is also very important. Child, grandchild or great-grandchild of a citizen of India, and who is a spouse of foreign origin of an Indian citizen of India, or spouse of a foreign origin of a person referred to any of the 1, 2, 3 above. In all these scenarios, that particular person will be regarded as a person of Indian origin. The reason why we are seeing the definition is there are certain transactions or a certain permissions which is given for making investments in India by a non-resident or a person resident of Indian origin. Okay, so only these two category of person can make specific investments without getting any RBI or central government approval. So what are those investments? Also we will see in the next slides. So this is given as a, the definition is given for the person of Indian origin under the Deposit Regulations Act. So OCI again is a very important definition which says individual resident of India who is registered as an OCI card holder under the Section 7A of Citizenship Act. Okay. So now what is Section 7A of Citizenship Act? That is very important. If you look at registration of OCI card holder, okay, it says the central government may, subject to such conditions, restrictions and manner as we prescribed, okay, made in this behalf, register as an OCI card holder any person, okay, any person of full age and capacity who is a citizen of another country but was a citizen of India at the time of commencement of the constitution, who is a citizen of another country but was eligible to become a citizen, okay, of India at the time of the constitution, who is a citizen of another country but belonged to a territory that became part of India as after the independence, or who is a child or grandchild or great-grandchild of the citizen. Okay, so this is the definition which is coming from the Registration Act of the OCI 7A, Section 7A. Okay. It also says any person who is a minor child of a person mentioned in clause A above, a person who is a minor child and whose both parents are citizen of India, or one of the parents of this are citizen of India. So that also is, that person also becomes an OCI. Spouse of foreign origin of a citizen of India or spouse of foreign origin of an OCI card holder. So it also says the same definition, and subsisted for a continuous period of not less than 2 years immediately preceding in the business. So this is also very important definition. Okay. Now, the central government may, by notifications of official gazette, specifies the date from which the existing persons of the Indian origin card holders shall be deemed to be OCI card holders. Okay, OCI, overseas investment. So this is also allowed. So basically, government also can set the rules for a specific purpose on whether from when they can become an OCI. Now, what are the remittance facilities for NRI? Okay, so this is also very important, and why this is important is because NRIs don't generally have that tendency of having that limits for which amounts can be transferred. So, what are the limits and what are the income streams which can be transferred easily, and which are the income streams which has to be transferred with specific permissions or specific restrictions? So, if you look at this remittance of current income, that is like rent, dividend, pension, interest, etc. of NRIs or PIOs, okay, that is freely allowed to be transferred. Okay. The only condition is all those incomes should be tax paid in India. Okay. It is freely allowed. So one declaration also we have to give to the banker saying that this is the tax paid interest income, or if it is not applicable, then we have to give the declaration that since we are non-resident falling under the bracket of Income Tax Act, then in that case it is not for us to have a taxation in India. So that's why with that declaration, the transfer from the banks can happen.
But when you say applicable tax, only income tax or
no, it says applicable taxes. So FEMA Act does not specifically say Income Tax Act, it says applicable taxes. So if GST is applicable, That is a transaction based anyway, so that will be, I mean, for that also it has to be paid.
Certified, you have to look whether GST applicable has been paid or not, or only income tax.
No, when we don't, the undertaking is given by the client himself itself, which says, if I am transferring any funds from outside India, it is a tax paid this one. I mean, income tax paid this one. So bankers are looking only from the income tax angle. Okay? But FEMA Act clearly says it should be tax paid. Tax paid means that income should be tax paid. Now, if we can take here an interpretation saying that since it is my income, for which I am liable to pay taxes only for the income tax act purpose. GST is a transaction based tax for which anyhow the GST tax this thing will be levied. Okay, but having the widespread RBI's arms and everything, it is we recommend that both taxes are to be paid and it is to be given as an undertaking to the banker, saying that we have paid the income tax act as well as if any business transactions are there, we have paid the applicable GST or any other taxes for that matter, not only GST, the labor law taxes or any other employer-employee relationship or any other those taxes are there. So that is also being paid, and that declaration we are giving it to the bankers, and the bankers after that they can transfer.
Should, as a CA, we should take that declaration.
No, it is the self-declaration by the client to the bankers.
But we have the certificate that all taxes are being paid. How do we safeguard ourselves?
So you mean to say while signing the audit reports?
Yeah. You are asking
No, here-
appropriate certification by CA.
So okay, no, this is for the purpose that the proposed remittance is eligible for remittance and that applicable taxes have been paid for. So when we are seeing that, so this is basically this you mean to say when we are certifying it, right?
Yeah.
Okay, so that certification when we see the common things are, let's say we can see the books of accounts of the because all these other taxes will come as a taxation for the books of accounts. I mean from the assessee itself. So we can say GST whether it's paid. Okay, the filings will be there. So that will be one part. Second is from the labor law side whether what all the filings are done. Third is from the income tax act itself also. It says that whatever income taxes are there, that for that particular assessee, it's a tax. Since it's a tax resident in India, it will be tax paid in India. Okay. So those are some of the criteria. It is a general check what we can do from the assessee side. So
No, it is not about the tax being deducted. It also evidence of tax has been paid, correct?
yes, correct.
Okay.
So the evidence is also that the tax has been paid. Yes.
So one more question. Actually, I'm an NRI, Jimmy, right? And I've had rental incomes for the last 10 to 15 years, right? And when a chartered accountant, as a chartered accountant, when we see that NRI transactions, if they have declared income and if they have filed and paid all the taxes, is it good enough for us to certify, or we have to look at the the transaction flows of that income coming into the bank account? Did they actually spend that money? Did not spend that money? The whole bank transaction flow has to be looked at as well.
Yes, sir. So this question will be like kind of the answer will be yes. As a certifying chartered accountant, we have to look at all the flows of transaction, how it has come, whether that transaction has been paid, taxes have been paid for that particular purpose or not. The reason being, now the AD bankers, okay, they are not doing their own due diligence, okay, they are relying completely on the CA certificate. If you give a CA certificate, AD bankers are like, okay, fine, we'll go ahead with that and we'll go through. The liability will fall on the chartered accountant. So it is always better to do a proper due diligence before issuing any of the certificates, certifying that whether the taxes have been paid or not. So that is our liability which we have to take. And as a chartered accountant, we also appreciate and tell the client to maintain documents, because NRIs don't maintain documents when they're paying in India, right? And then when they see and come back and say that okay, the tax has already been paid or whatever is the scenario, we always opine to the client saying that maintain the proper documentation, which will be useful for verification by any of us, like any of the bankers also or chartered accountant, or also from in future if the RBI also comes into play. So that also will be better. So that we can very well guide to the clients. Okay. So now if you look at the remittance angle from the definition as such, remittance of asset means remittance outside India of funds representing a deposit with a bank or a firm or a company provident fund balance or superannuation benefits, amount of claim or maturity proceeds of insurance policy, sale proceeds of shares, securities, remote property or any other asset held in India. Okay, it is very important. Any other asset held in India in accordance with the provisions of the Act or rules made applicable. Okay. Now, a very common thing which is given is, a very blanket, permissible limit is given. An NRA or a PIO may remit an amount up to $1 million per financial year out of the balances held in its NRO account. Okay. So this is very important because if you look at the difference between the NRO account and the NRE account, NRE account clearly says whatever current incomes are had that can be properly credited, and that transfer from NRE account does not have any maximum limit. But if you look at the NRO account, there is a maximum limit coming as $1 million. Okay. So that is coming only in the NRO account. So out of the balances held in its NRO account, sale proceeds of assets, okay, inclusive of assets acquired by way of inheritance or legacy, on production of documentary evidence, under the deed of settlement made by its parents, etc. Remittance of all investments shall be made through the same authorized. This is also very important. You cannot always change your banker's transaction by transaction. So even if you go to a different banker, they will always ask for a AD bank change code or AD bank, declaration from the old bank that okay, all the transactions are happening. So this is also very important. This is the reason being the flow of the transaction can be known if it is there from the one banker. Remittance from the balances held in the NRO account and undertaking to AD, that they said the said remittance sought to be made out of the remitter's balance held in the account arising from his or her legitimate receivables in India and not by borrowing from any other person or a transfer from any other NRO account. And if such is found to be the case, the account holder will render himself or herself liable for penal actions under the FEMA. So this is very important. A CA certificate also is required in Form 15CB and undertaking by remitter in Form 15CA. We generally thought that okay, 15CB is only for the purpose of Income Tax Act and international taxation and DAA and all those things. But FEMA also, from somewhere or the other angle, if you look at the 15CB angle, it says the TDS, whatever is the amount on the amount of transfer on which the amount is chargeable to tax in India, the taxes are paid in that India, okay, as per the TDS provision. Now, to arrive at the amount, you need to be very careful in ascertaining whether it's a current income or a current account transaction or a capital account transaction. So indirectly, the FEMA provisions also comes into play when you are certifying through a 15CB also. Okay, so this is also very important. If it is an amount chargeable to tax in India, we need to see from the FEMA angle also whether it's a current account transaction, capital account transaction, whether it's permissible to do it or not. Because once we certify 15CB, we tell that okay, this is amount chargeable to tax in India, this is the TDS which is payable in India, the balance amount can be transferred outside India. But we generally lack to see that okay, from which account it is getting transferred, whether it is more than $1 million, if it is getting from the transfer of the NRO account, then we as a chartered fund also should not issue a 15CB in such a scenario. That way this FEMA applicable also.
So for example, I'm an NRI and I need money urgently for very basic life medical, studies for the kids, and I don't have any money in India and I don't have enough money from my earnings.
Okay.
So I have property from India, and I go and I pledge to the bank and get money. That comes under this borrowing from any other person. You cannot remit it back even within $1 million USD.
No, this is pledging for the immobile property. It will be covered under the immobile properties regulation, which I am covering in the next slide. On which charge or pledging or mortgage is also allowed and applicable, which you can very easily transfer.
It's a capital account transaction.
Yeah, it's a capital account transaction, which you can transfer.
But when you are saying that PCB, we are only certifying whether the tax has been
Paid in.
paid or paid at all. But why should we look at the other angles from the FEMA, whether it is a capital account, current account and all that? Because our limited role is to say whether tax is paid or not.
Correct.
If the authorized data, we should say authorized.
Correct. Now, if you look at the last point in the 15CB, it says net amount. Net amount to be out of the TDS after deduction.
But we are not approving that.
Yeah, you are not approving that, but that is a net amount which you are saying that this amount is transferable, because 15CB is only when you are making any payment to outside India, whereby for which a declaration we have to give to the AD bankers saying that okay, this is a tax paid amount. So the balance net amount can be transferred. Now that is an indirect indication which the CA is telling that okay, this net amount is transferable. Okay, that
You're
means
not giving permission.
no, you're not giving permission.
You're not authorized to do that.
Correct, sir. But at the end, what you're telling is this amount, the TDS amount is there, which is to be deducted and paid in India, which you have done it, which the SSC has done it properly, and then balance amount is transferable. This 15CB certificate is not to certify that the TDS amount is there so much. We generally have a interpretation saying that if we are issuing a 15CB, we will see what is the TDS rate, okay, whether the TDS rate is properly done or not, okay, that is fine. But actually the 15CB is for the purpose of remittance outside India. That is a declaration which you are giving to the AD bank. That means if, yes,
15CB is under income tax act.
correct sir,
Not
15CB,
FEMA.
correct sir, 15CB is,
Can you treat it as a FEMA company?
no, correct sir, 15CB is coming under the Income Tax Act only. Income Tax Act is guiding the form structure and the applicability of 15CB and the issuance of 15CB, that is fine. But the interpretation of the 15CB, how the receiver is taking is, this 15CB is for the purpose of remittance outside India. It is not for the purpose of, not only limited to the purpose of whether TDS is getting deducted at the proper rate in India or not. So that's why you need to be very careful in giving a 15CB in case if there is an NRO limit, okay, which let's say for example more than 1 million USD, okay, then that is specifically not
Purpose code, what about the purpose code is in FEMA or
No, no.
This you are giving the purpose code. Where is it?
The purpose code means, I mean, the
We are,
15CB.
only we are certifying the purpose code and then
Correct. It is not coming from the Income Tax Act. So the purpose code is generally given by the RBI only. The purpose codes for the purpose of remittance
it
or
is based on the FEMA or
no, it is a general purpose code. It is not based on any other law, any law. It is based on the nature of what transaction you are doing. The purpose code we need to mention, which is given by RBI to the bankers, and that bank, the same purpose code we need to mention it in the form 15CB also. So that's why it is required to be seen from all the angles. Even from the FEMA angle, if we are saying that the transaction, we can transfer the money, indirectly we are giving a hint that as a chartered accountant, this amount, whatever is there, this is tax paid in India, and the balance amount, whatever is there, is transferable outside India. Yes.
Directly I put it the other ways. Your 15CB will become invalid if it crosses 1 million. And if there is no, if that transaction is not allowed, your 15CB will be invalid.
Correct, sir. I understood your point. But this is in this current scenario where this 1 million USD, I just gave it as an example. Yeah. But if any other transaction is there where the remittance is
No,
not
I am answering this question.
Okay.
Your 15CB will become invalid. The banker will not allow the transfer.
Correct, sir. But the point is, if the 15CB, even if it becomes invalid, we have issued the 15CB. So somewhere we have given a interpretation saying that the amount which is there, which is transferable. Yes, you can transfer it, but it is becoming invalid because of the structure and the banking admin aspects and operating aspects, whatever is there. So before issuing the certificate, we need to be cautious. Yes, we have to be cautious from the FEMA angle also. So this is a very important point which
not only you look at the purpose as well.
yes, sir. The purpose and actually the interpretation of 15CB is we are telling the bankers that this money is transferable outside India. You can very well take it up because the amount of taxes is paid in India. But we cannot restrict ourselves to saying that okay, what we have seen, okay, this is the income, 30%, 40%, whatever tax is there, or 10% as per DDAA, taxes is paid in India, that's fine. But we are also telling that the balance you can transfer outside India. That means that the interpretation is coming as a amount, whatever we are transferring outside India is getting approved by a CA. And not only the TDS amount which is there.
FEMA compliance also.
Yeah, exactly. The FEMA compliance also we need to see whether it is prohibited or not, or whether it is restricted or not. You cannot issue a 15CB for a gambling or a lottery ticket where specifically prohibition is there. And you cannot come out saying that okay, I have seen okay, TDS is applicable, TDS is paid, that's fine. So that's why I have given a hint that you can transfer the money. So very well RBI can come and question you that what the purpose, for what purpose you have issued this certificate.
So like we are certifying.
Yeah.
Actually, we are certifying for a transaction or issue 15CB. Yeah. So like that client, he may have multiple transactions. As you can see, $1 million per financial year. So we may be certifying one transaction. So at the time, we may not aware that how much amount he has remitted earlier. So we are remitting like 0.5 million. So we have certified. like whether we need to check all these previous evidence also at the time of certifying this any transaction.
Yes, sir. If it is coming, if it is going outside from his NRO account, we are very well required to check this. Because the reason being it says per year. So for that particular year, you need to check whether it's more than $1 million. Secondly, as sir also rightly mentioned, even though if you are issuing a certificate, the transaction itself will be void because it will directly stop there in the banker side of saying that it is exceeding your $1 million. So this is one of the example which says that even before issuing the certificate also you need to be very careful in giving an certificate saying that even if you are transferring or beyond, below the 1 lakh million for that particular transaction, but for the whole year you have already done it. In that case, it is very much appreciated to check your full year's transaction.
How do you check whether $1 million is exceeded or not?
Sir, NRO account we can get a statement from the bankers, or we can get a declaration for that particular NRO account, or we can get a declaration from the client that you don't have any other NRO account with any other AD bankers. So that based on that only we can do it, sir. But we have to get something. We cannot say that okay, because we cannot get any declaration, the client is not getting it, we have not got it. So that cannot be a reason for issuing us a certificate.
So if client hides some information and says that suppose he has 4 NRO accounts,
but he says only one. In that case, is the risk avoided based on a determination from the bank?
Yeah. Lastly, we'll always mention that based on the best available knowledge and data available. So that
protection is available.
That protection is always available. But we have to follow the procedure. The procedure should be followed, the documentation should be maintained. So that is what is required.
Okay.
Yeah. So we have seen that what are the remittances and why the importance of 15 CT and 948. Get a 948. Okay, just. I think okay, sir. So I think we'll quickly get back after a short break. 15 minutes, sir.
Yeah.
So 15 minutes we'll be back. The feedback that voice was a little feeble and for most of the session. So I'll just try to keep it near and if anything is there, just raise your hand so that I will also make the changes. Okay? Now we have looked at the basic provisions of the FEMA with regard to the definition, residential status, bank accounts and LRS limits, current account transactions, and what are the interpretation of the FEMA and the preamble of the FEMA, right? Now a very important and very misinterpreted the transaction which we call is the immovable properties part. Generally what we say is any person who is outside India is not allowed to invest in immovable properties, okay, in India. That is true because the as we are mentioning, the law says that if you want to invest in an immovable property in India, it has to be specifically allowed under the Indian regulations, okay. So if you look at the specific regulations are given for NRIs and OCIs, okay. Any non-resident Indians or overseas citizen of India, for them it is generally allowed. For others other than NRIs or OCIs who are resident outside India, that means foreign nationals, generally it is not allowed, okay. Only in specific circumstances you can very well acquire a property in India. Now we will see an overview of how this particular regulation works, okay. So it is coming from the recently in 2019 the FEMA NDI rules which made this amendments, okay. From Rule 24 to Rule 33, it all talks about the immovable property acquisition and transfer. Now if you look at the overview of what are the modes of acquisition of immovable property in India, right? NRIs or OCIs, they can purchase through funds from inward remittance, okay? They can purchase, it is allowed for NRIs and OCIs. That's why the definition of OCI is very important. They are also allowed to get it by gift or by inheritance from any person resident outside India. So let's say if any foreign national, he was previously there or before independence or before the FERA Act came into play, he was having a property in India, okay. Recently we also saw one of the superstar, I think Devanand or I don't know the exact name. He was having a property in Pakistan because it was acquired by him pre-independence. So the recently only the order came for which the Pakistan government has taken that property from him, for which a consideration was also paid to him. So like that, if any property is also there for a foreign national in India, they can very well hold it. Section 6, subsection 4 and subsection 5 very well regulates and tell you that okay, it is not a problem for you, you can very well hold that property and continue holding that. From that person also through inheritance, an NRI or an OCI can very well get a property, immovable property in India. Now if a foreign national or citizen of non-Indian origin, then how can he get it? Only through inheritance under section 6(5), or else you cannot get any immovable property. Joint acquisition with NRI or OCI spouse, okay? Lease which is less than 5 years. You can very well get a lease for less than 5 years of any property. So generally if you see any investments or anything done by an individual, okay, it happens through lease, and that lease again it gets renewed. For a permitted activity. Now what is this permitted activity? A specific permission is given, like for example foreign embassies and diplomats, okay? Anyone who is embassy person or a consulate general in India, they can hold up immovable property in India only where the notification specifies within a specified area or a specified limit notified by the government. So within that area or within that limit, they can very well hold a property in India, even though they are a foreign national. Now, what is this LTV holder? Okay, if you look at any person, okay, being a citizen of Afghanistan or Bangladesh, that means any land borders, okay, or Pakistan belonging to minority communities in those countries, namely Hindu, Sikh, Buddhist, Jains, Parsis and Christians, may purchase one residential immovable property in India or one immovable property for carrying out self-employment, okay. So this is also allowed for the minority communities of that particular country. This is because of the very much fact that post-independence a lot of clarifications was required with where the persons already had property in India, or whether they can purchase it after that, or whether their own next generations can purchase. So because of which this notification has came, and it is generally allowed. Now if you look at what are the source of funds for acquisition, out of funds received in India from abroad through normal banking channels by way of inward remittance, out of non-resident account, NRO, NRE, FCNR account maintained in accordance with the Act, out of the non-resident account maintained in accordance with the Act of, okay, I think it's repeating, okay. So blanket prohibition by RBI, no payments can be done by traveler's check or foreign currency check, okay, it is very important, because generally what people do is, okay, if it is allowed, then it is allowed from all the angles, but no, we have to also see the admin angles. Which account length it is allowed, or which account is specifically prohibiting. That is very important, because this nobody will stop. Even the AD bankers cannot stop you, because as I rightly said, they don't even do the due diligence. We generally have that intention and perception that AD bankers will check it and we just have to go it. But to be very frank, AD bankers will never do the due diligence. Tomorrow after 5-6 years, RBI will come and tell, boss, you have transferred from this account which is not allowed, now you pay the penalty. So that becomes a, the penalties are also huge. We'll quickly take you through the last slide also, where I'll mention penalties for a smaller non-compliance also, okay. If you're submitting any form, late form or a form ODI or FCI which you have forgotten to submit, and if you're submitting late, the penalty can range from 200 rupees per day to 5,000 rupees per day. Per day I'm talking about. So let's imagine for 1 year itself, if you have not done, what is the level of the amount which you need to pay, okay? And if they come after 5-6 years, then I think the client itself has to go underground and and there is no limit also. They can even come back after 15 years, okay? Because RBI Income Tax Act madri 6 years, 8 years concept RBI can come back anytime. It's like the Black Money or the Prevention of Money Laundering Act, okay, where they can come back anytime. Now this is the general, the flow from where this has to come. Now I've just summarized it. So if you see acquisition, purchase other than agriculture, this is also very important. Agricultural land is only specifically allowed. Other than agricultural land only is covered under this immovable property. If you want to purchase any immovable property which is an agricultural land, right, then a specific permission has to be compulsory taken, which is generally not given by the RBI. But but a law is there whereby you can very well tell that you are setting up a business on that agricultural land, and still for that business of grains or pulses or anything related to food processing, you can very well still go and apply for the RBI permission, but generally it is not given. Okay. So a purchase other than agricultural land, resident NRA OCAs can do it. Acquire as a gift, they can do it. Inheritance from any person who has acquired under any law. Okay. Sale, if you sell other than agricultural land, that is also allowed by NRA. I mean resident NRA and OCA. Okay. Gift is allowed by resident NRA and OCA again. So I've just summarized this. This is the meaning of immovable property, which generally comes as a non-debt instrument. Okay. It is basically considered as a non-debt instrument. Reason being that it is an asset, and there is no specific definition also given for the immovable property. A general meaning is applied. So what an NRA and OCA cannot do, it is very important. They cannot buy agricultural land, plantation property and farmhouses. NRA or OCA cannot do real estate trading or trade in transferable development rights. This is also very important. Now one amendment has come which said that real estate activity is prohibited. However, if it is for the purpose of manufacturing or if it is for the purpose of expansion and growth of your business, then in that case purchase of real estate activity is allowed. So this also opens up a ambit of litigation, because there is no clarification in this particular regard as well, that whether that definition which is coming as the allowability of purchasing a real estate property is given for the purpose of an individual or for the purpose of an entity as a whole. As a person as a whole, individual as well as non-individual. That is number one. Number two, there are no references law, because this amendment has come only in the recent regulations in 2022, which said that the definition of real estate activity was given. Okay. So even when we had a couple of practical experience with the AD bankers, even the AD bankers are telling a very nicely interpreted law which says that a real estate business activity definition is not there. So that means it is allowed. So it is not the fact. So if you have to look at the FEMA, if anything definition is not given, you have to take it in the interpretation that it is not allowed and not the vice versa way. So it has to be specifically allowed, then only you can very well invest in that. So since the definition clarity and the clarifications are not there, even the AD bankers are not sure. So what they are doing, they are going for a blanket approval from RBI. And if it is getting rejected, that means it is not allowed, and if it is getting accepted, that means it is allowed. So from the law, they cannot tell whether it is allowed specifically or not. So subject to the guidelines, funds can also be repatriated from without a sorry.
Yeah, so the previous one, right, you're talking about real estate, since there's no definition of real estate. As an NRI, if I just decide to buy land, right, just one land, right, and then I sell it after some time, maybe 2 years, 3 years. Is it considered as this, or is it based on some frequency because there's no definition?
Definitely not based on frequency, sir. What it is, what we have to take is from the angle of your intention. Now, this is also a litigative aspect. Intention can be obtained from 1, 2, 3 parameters. One, what is the objective of your company starting? Let's say if you are opening as a company in India, what is the objective of that company? Whether that object includes trading of investments or not, number one. Number two, if the object is not there, what is your intention? Intention can also be taken from the transaction which you do, not on the frequency. Let's say if you're transacting only in this one, the property, and you don't have any other transaction of business, that will be regarded as a real estate business activity also. Okay. So all these parameters comes into play when you have to deal with the real estate business.
Okay. Just in this case, I'm not even starting a business. I'm not even starting a company.
Okay.
As an individual NRI, I decided to buy a land.
Okay.
Because I just have money, I've remitted money to India, I want to invest somewhere, right?
Okay.
So I just buy a land. I keep it for some time, 2, 3 years, 4 years, right? Then the intention is really an investment and not trading.
True. Then in that, yes. Then in that case, if your intention is for the purpose only for investment, then it is not a real estate business. That is very well allowed. That's why these regulations also tell that you can buy an immovable property. The intention for investing in a real estate business is not allowed. So the sale proceeds also can be touched, please.
As you said earlier,
So non-residents
cannot purchase an immovable property.
Non-resident foreign nationals.
Foreign national. So what happens in the current scenario? Non-residents, they floated a company in India. So you can say 100% subsidy in India. Whether that private limited company in India can purchase an immovable property?
No. So that when they have invested, they would have filled the form FDI. In that FDI, what is the object of the company? The objects clause, the memorandum articles, they will have the objects clause. So what is the objective of floating that company in India? Whether it is in the business of real estate, then it is not allowed. Then in that case, you cannot even at the first place invest in the FDI company in India. So let's say if you have invested for some other business purpose, and as an addendum to the business, it is also starting as a real estate business activity as one of other businesses. Then the NRI should mandatorily disinvest the investment and take back the funds. They cannot continue as an investor in that particular real estate business unless a specific approval is obtained from the RBI.
So in the current scenario, they are into software business, like software. So to run that business, they need a property because for the employees they need to stay commercial building.
Correct.
So whether they can purchase.
Yes, correct. So this is a genuine or true hardship which is coming. So that's why recently this real estate business definition also has come. Okay, which says that if any investment you're doing for expansion or growth or for the purpose of your business or setting up township or construction for your employees also, all that also is allowed. Secondly, also if you look at previously, people also used to take properties on lease basis, okay, more than 10 years or whatever it is, 10, 11 years, 99 years, whatever it is. So that also is generally allowed. So on lease basis also you can take it, but purchase of property directly by a foreign national is not allowed. They cannot be an owner of the property unless it is specified or they have done it through a legal means.
Can a foreign national purchase a 99 years lease on his own account?
Yes.
He can purchase.
As per law, yes.
Okay.
But this has to be reported to RBI. RBI does not permit. This is what is happening, sir. The AD bankers are they are telling.
There are cases where they permit as well.
Yes, but what's the purpose of taking that lease? Generally, what they do it in for the purpose of business, for the purpose of expansion, for which you need to tell them that okay, I already have a set up business, I already have an here establishment which I want to set up a plant and machinery for which I want to buy a land or whatever it is, and that land or building is bought in the name of the Indian subsidiary in which I am having investment. Then that becomes a genuine case whereby RBI can give you a permission. Or else
I can't do it on my own account.
you can do it, sir. As per law, it is allowed. On your own also you can set up a business and start doing that activity. But that becomes difficult to.
No, I'm not saying for purpose of business. I have a business, but I want to do I want to own a property in India as a foreign national.
Then, as a foreign national, you cannot do. As a foreign national, you cannot do. That is for sure. Lease is there only for the purpose of business. I'm telling you.
Okay.
So as a foreign national, you cannot purchase property. So that is very well, accepted.
RBI will not allow it, or
RBI, no. Law itself does not allow you. But as a foreign national, still you can purchase a property or lease a property for the purpose of business. That is allowed. As an NRI, you can very well purchase a property. That is not a problem.
Whether this private limited subsidiary, whether it needs to take approval, he wants to invest.
Private limited subsidiary.
Subsidiary of a foreign national.
Okay.
Whether if it is purchasing the property for the course of business, whether it needs to take the prior approval or.
For the purchase of property, you don't have to take an approval. But at the time when the foreign investor is investing in India and floating a subsidiary company, at that time you need to mention in which infrastructure, in which sector or which industry this company will be operating as a business. That will be real estate activity. Then we have to see performance linked conditions whereby whether 100% FDI is allowed or what is sectoral cap for this particular sector. 100% FDI is allowed or 50% is allowed or not allowed or allowed only with specific permission. All those things will happen in the first place itself. Where if you mention the object of the company as a real estate business trading.
when you do a FCTRS form, this as per subject.
Yes. Yeah, FCTRS form or FCGPR when the new issues there or issues there.
For agriculture, they are floating the money through their relatives only.
Sorry, sir. Not able to.
For purchasing agriculture land, they are transferring money to their relatives.
Yes, sir. All those things are happening. But there's no connection where we can say that it is ultimately the funds are going in, because the owner of the agricultural land is the relative, the beneficiary also is relative, everything. After the books in the capital account, when it happens as a drawings, after that what it's happened we don't know. So these are the things which is happening because of the I mean, you can call a loophole, or you can kill the only option available to invest.
In this case, sir, it's a software company with a foreign parent. The software company is running operations inside IT Park and wants to acquire commercial space to run the business.
Allowed.
Yes. So the money will come as FDI with
Yes.
the appropriate board. And
Yes, that is generally allowed. You can purchase a land also, you can invest your, but you need to show proper, connotation that it is for the purpose of the business. For that, how we will do is, you can take a purchase order quotations, or PO, purchase order for the purchase of the plant and machinery, or a sale deed or a sale agreement with the landowner saying that I have already entered into this for the purpose of business. All those things will add on to your documentation. Thank you. I think we'll quickly move and summarize the slides. One is transfer by NRI or OCI. It is allowed, okay, to NI, NRI or OCI any involved property other than agricultural property. So the transfer provisions and sale provisions and repatriation provisions also apply in the same level what it is there for the purpose of investment. Okay. Now if you look at this rule I have given for the purpose of repatriation of sale proceedings of involved property. So generally it is allowed. Okay. What it says is, a person referred to in 6.5, okay, who holds, a person resident outside India, who holds, owns or invests in any immovable property situated in India, okay. If such property was acquired, held or owned by such person when he was resident in India, okay, then his successor shall not, except with the prior permission of the Reserve Bank, okay, repatriate outside India the sale proceeds of any immovable property referred to in that subsection. Okay, now here very important aspect is, what it says, sale of immovable property, okay, in India by an NRI or an OCI, AD may allow repatriation. AD is the authorized banker. So authorized banker itself may allow the repatriation of the sale proceeds provided the following conditions are satisfied. What are the conditions? Immovable property was acquired by the seller in accordance with the provision of the law, okay, at the time when it was existing. The amount of acquisition of the immovable property was paid in foreign exchange received through banking channels, okay. So that means, see, here it will be getting caught. Let's say if you have invested through some other channel or some other account from which the investment was not allowed, then you will not be able to repatriate the money at the time of selling of the the immovable property. Okay. So in case of residential property, the repatriation of sale proceeds is restricted to not more than 2 such properties. Okay. This is also very important. And if you have to sell beyond that, then a specific permission is required from the RBI. Now, what happens when there is a change in the residential status or a citizenship? So resident who becomes a non-resident can continue to hold property. It is given in section 6 subsection 5 of FEMA. Okay, that is very clear. Agricultural activities cannot be conducted in agricultural properties. This is also very clear. People who acquire foreign citizenship can continue to hold property in India. They should acquire OCI card although. So Rule 33 will be helpful for this, which is given how to acquire OCI card, because that will serve you as a proof in terms of holding the property in India. Okay. Non-resident who becomes Indian residents can continue to hold property, but repatriability is lost. Okay. Foreign citizens who become Indian citizens can continue to hold the property.
Can you explain the first point? See, suppose I am coming from a remote village in Tamil Nadu. I become a non-resident. I am a resident. Later I become a non-resident. Suppose I can continue.
But you are saying I can continue to hold agricultural property, but agricultural activities cannot be conducted with. Suppose if my parents are doing agriculture, can they continue to hold it? Can they continue to do it?
No, sir, because ultimately you are the beneficial owner of the property.
Okay.
And the agricultural activities will be conducted by you only. You can transfer the property to your parents' name who are resident in India, who can continue the agricultural property. Now we'll quickly see investments by NRIs or OCIs. Okay, what are the general investments which is available by NRIs or OCI apart from the immovable properties? Okay, so purchase of these are specific rules which is given in non-debt instrument rules. So here, if you look at even in our presentation, what we are discussing, we are jumping on the rules, different rules, different acts, because that is what necessary is also there, because the concept does not arrive only from one rule or one regulation. We have to see all the rules and accordingly take the concept and interpret the law. Now, FEMA non-debt instrument rules clearly says on the part of what are the investments which the NRI or OCI can make. So there are, if you also see the rules, Rule 6A is purchase or sale of equity instrument of an Indian company by person resident outside India. Then Rule 12 says investment by non-resident or OCI on repatriable basis. 2A2 says on non-repatriable basis. Rule 6B, again it says investment in LLP. Okay, so there are different rules which is given for different type of structuring or what type of investments you are going to make. Okay, now I'll just quickly summarize this as well. Equities, instruments and other securities. Okay, let's say equity instruments of a listed Indian company. Funds up to value on shares which is less than 5% for each NRI. It is allowed to be invested in India. Okay. Aggregate investments by all NRIs summing up should be less than 10% for that particular company. Then it is generally allowed for any listed company, because this falls under the bucket of the portfolio investment. So generally less than 10% now, people will not be, the government will not be more keen on it. However, if it is going more than 10%, then upper limit is 24%, where the company has to pass a special resolution. So that is also allowed. Beyond that also you need to get a specific permission from the RBI. So this is generally it is allowed. And units of domestic mutual funds investment greater than 50% in equity should be there. Okay, then only units of domestic mutual funds and ETF you can purchase it. Purchase or sale of shares issued by public sector undertakings. Okay, that is also allowed to be taken. Subscription to NPS in accordance with the pension fund. So NPS, the pension fund law also NRIs can invest it. That is also allowed. But they have their own regulation and they have their own conditions based on which we need to adhere. The mode of payment, very important. The amount of consideration shall be paid as inward remittance from abroad through banking channels or out of funds held in NRE account. Okay, very important. So we can have a, for the simplicity's sake, NRE account we can do anything, whatever we want. NRO account has a lot of restrictions. Okay. So generally, if you're dealing with any transaction which involves NRO accounts implications, you need to be very careful. Okay, because NRO account has in the FAQs itself, if you see, a beautiful tabular column is given whereby permissible debits and permissible credits are given from NRE account to NRO account. That itself, if you read, you will come to know that okay, what are the conditions or what are the implications which it can come to if you invest from NRO account, or what are the available options it is there. NRE can purchase shares on repatriation basis. Okay, so that is very well given. It is coming from Schedule 3 of the NDA rules. Paid up value of shares less than which we were discussing. Okay, all the conditions. Now equity instruments also we have discussed, which is coming from Schedule 4. Okay, of the NDA rules. Now what do you mean by non-repatriable? Now we are discussing repatriation basis, non-repatriation basis. The basic definition is anything which you can take back the money. That is the principal amount and not the income. Okay, the principal amount whichever is there which you can take back is called repatriation basis, and the principal amount basis which is not allowed to be taken back or specifically allowed only with the permission from the RBI, it is called a non-repatriation basis. Okay, it is not talking about anything with regard to current income or anything. Current income is generally a repatriable income only. However, the only condition is you need to pay the taxes in India. Okay, so that is the common law which is there. Now, if you just quickly, I think Schedule 4 is there for investment by NRE on a non-repatriation basis. This has some conditions which is in terms of more in terms of restrictive in nature. Okay, because generally it is not appreciated to invest as a non-repatriation, even though if it is in FDI or even though if it is an ODI, generally it is not allowed. Now, I'll just summarize this. Let's say what are the eligible investments and what are the maximum limits for that investments. Transfer of sale. Okay. So basically, if any investment is there, then the transfer, whether it is allowed or not, so generally it is allowed through sale or gift. But the problem here is we need to see the subject of sectoral cap, pricing guidelines and other reporting requirements. Okay. The reason being, if an NRI or OCI is investing or it was already invested as a resident in India, it does not fall under the bracket of FDI. Okay. But however, if they are investing, if that particular resident, okay, is transferring to a non-resident, okay, then the sectoral cap and the reporting requirements and pricing guidelines will come for the purpose of FDI. Even though it is an already set up company, already set up shareholders, it is just a transfer of shares, still the FDI regulations and conditions will be applicable. That means some of the sectors, let's say defense sector, okay, recently only they have given the percentage of 100, or some of the sectors which has still 49%, okay, then that means if the shareholders are transferring shares for more than 49%, it is not allowed as per law. But nobody will restrict you. You can transfer the shares because it is an off-the-market transaction whereby the money is coming from the bankers, AD bankers. You just have to give a declaration saying that you have adhered to all the FEMA regulations. But if you are unaware that the FDI regulations and sectoral caps will be applicable, that declaration also does not hold good. And whatever investments you have received, okay, from that particular company, the company will be liable. The Indian company will be liable. Okay, so that's why if you look at the share transfer agreement, what we have, SH4 and all, that has to be submitted to the Indian company also, which there's a portal in the RBI called as firms portal, okay, whereby you need to mention what is the change in the shareholding pattern. The annual forms also which you mention in the RBI, then also you need to mention what are the change in the shareholding which is happening, and that change will not be accepted if that particular industry or that particular sector of FDI is crossing the sectoral cap limit, okay, or if it has any permission with regard to specific conditions to be adhered to, okay, then in that case all those factors will come into play, even though if it is a transfer or a sale or a gift. Now, if you look at, okay, these are some of the prohibited sectors are Nidhi companies, agriculture, plantation, real estate, construction of farmhouse, or dealing in transferable development rights, okay, these are all prohibited. Now, proprietorship firm, okay, it is very important. Can an individual open a proprietorship firm in India as an, just as an individual, as how we are having a proprietorship firm? As per RBI, generally it is not allowed, okay. But we can very well tell that as I am doing a business, okay, under the capacity of the individual and not as a proprietorship firm. So there is a difference between the two. Proprietorship firm is basically, it's an entity only which is to be set up, but it will be in individual name, okay. As per law, as per FEMA, it is not allowed. You can, as a non-resident, you can invest only in a partnership firm, that too an LLP with certain conditions, okay, or under a company and do the business, and not under a proprietorship concern. Now, okay, these are also the same which we have already discussed. Very important. If any entities of Bangladesh or Pakistan or anything is there, I think this is coming from the next slide. Okay, so if any recent notification which came during the China thing which was going on during the COVID period, and if any investment which is coming from land bordering, okay?
Press note 3, press note 3.
Yeah, exactly, yes, correct. Very right, sir. So, if it is coming, any investment is coming from the land bordering countries, right? Then for those investments, it will be done through a specific procedure of RBI. It is not restricted, it is allowed, but it will be a specific procedure whereby a permission has to be taken from the RBI. Okay. So with this notification, lot of companies started to invest from Singapore or from other countries, whereby because from China directly they don't wanted to invest it. So they routed through Russia also, they routed through Singapore also. So these kind of transactions. But here, what the catch point is, this notification does not say direct investment. It says investment. This means it is also applicable for an indirect way of investment also. Okay, let's say if China is subsidiary, China holding, then subsidiary in Singapore, and from Singapore the funds are coming, and there's a clear direct route which is happening there. That also can be interpreted saying that RBI will not allow this kind of transaction unless a specific permission is taken. Okay, we can get. So generally FDI, whatever comes in India, that is allowed if it is falling under the sectoral caps and the conditions. This notification said if it is coming from those countries, it is not allowed. But it does not say it is a direct investment. It says investment, that's it. Okay.
So land bordering countries means China, Pakistan, Nepal and Bhutan?
No, Afghanistan also comes in, and then Myanmar also comes in, and I need to check whether Sri Lanka is coming in or not. So no, whether they take that as a land bordering or not is the thing. it might be, it might not be exactly a land product, but it's a neighboring country. So I'm not sure whether Sri Lanka is coming or not. I need to check on that point. But these countries are for sure. Afghanistan is also included in that.
Now, here's a question.
Yes, please.
Earlier slide question, foreign citizen OCI holder can be a partner in a partnership firm, not LLP.
So your question,
registered fund.
okay, so your question is foreign holder, OCI holder, okay, can be a, yes, that is allowed. Yeah. So now we quickly look at the foreign portfolio investment. What we already discussed is less than 10% of the amount, okay, of the fully paid up capital. So this is just the summary of the disclosure and the definition which has come in. Okay. Now we see the very important aspect of FDI. Okay. The overview of FDI is basically any investment in listed companies more than 10% will be regarded as FDI. Any investment in unlisted company, whatever be the percentage, less than 10% is also regarded as an FDI. Investment by NRI or OCI on repatriation basis is allowed as an FDI. Okay. Now, what can be a foreign investment and under what scenarios? Okay, investment in LLP, investment in sole proprietorship also with specific conditions. Okay, foreign portfolio investments is allowed. Investment in investment vehicles is also allowed. Investment by foreign venture capital funds. So this is also very important, which has brought in many investments in India. Okay, and investment by NIOC on repatriation basis is correct. So now we just quickly look at the main major definitions of these. The foreign direct investment. Okay, investment through equity. Okay, equity instruments. It does not say equity share capital. It says equity instrument. Equity instrument also means convertible preference shares or convertible any instrument which is convertible into preference shares. So that also will fall part as an FDI only. Okay. So in case in any existing investment by a person resident outside India, an equity instrument of a listed Indian company falls to a level below 10% of the post-issue paid-up capital on a fully diluted basis, the investment shall continue to be treated as an FDI. Okay, just because it is fallen below 10%, it will not fall as a portfolio investment. The reason this difference is required is portfolio investment does not come with a lot of restrictions. You can freely repatriate the amount and you can do the transfers and all those things are allowed. But whereas in the case of an FDI, it comes with certain conditions and the sectoral caps also. Okay.
Indian parent company issues ESOP to foreign subsidiary.
So Indian company issuing ESOPs to foreign subsidiary. Okay.
Employees of foreign subsidiary.
Employees of foreign subsidiary. So we need to see the nationality and the this thing of the employees. If they are non-residents and if the cumulative amount is more than 10%, which generally does not happen, then it will come under the bracket of FTA. Otherwise, it is generally allowed because it will become a portfolio investment within less than 10%.
Correct.
But if it is an unlisted company, then listed company, then it will be a portfolio investment only.
What they have to do, FTG only.
So if it is listed company for foreign portfolio investment only, which is less than 10% only generally in the case, then it is allowed. But if they
what
are
are the
issuing,
forms they need to fill in?
that I will take it in the next slide. Okay. Yes, sir. Yes.
Can a non-resident gift his share to a resident?
So non-resident gifting shares to a resident, yes, that is allowed with pricing guidelines. So a basic rule is any investment or any gift which is happening between non-resident and resident, India should be in the favorable stage. That means if any investment is going from outside India, the money is going outside India, it should not be more than fair market value. If it is coming in India, it should not be less than fair market value. Okay, that is the basic condition for any type of gift or transaction between a resident and non-resident. In your case, if a non-resident is giving gift to a resident, then the consideration what the resident is paying to non-resident cannot be more than the fair market value. And the fair market value is coming from.
It's a gift.
Gift also is allowed. Gift also is, but the definition of gift is restricted only to relatives. So that is also allowed, sir.
Gift is allowed.
Gift is allowed. Yes, gift is allowed. From resident to non-resident, gift is allowed.
Even if without,
Gift is without consideration is allowed. Yes.
Even if they are not related.
No. That we need to see, sir. The conditions we need to see. What is the nature of the investment? What is the nature? Whether it is a share or.
Yes, it's a share.
Yeah. Then it is allowed only if you are gifting it to a relative.
Or suppose if the non-resident gives to Indian who is a non-resident, is it allowed?
Non-resident giving gift
The
to?
non-resident holds shares in the Indian company. Can he give to an Indian who is not a relative?
I need to check this point, sir. If it is a non-resident to resident, who is a non-relative, whether gift is allowed or not. But generally, seeing the condition, it should not be allowed, because if it is a third-party transfer, it should be specifically at arm's length. The pricing guidelines will come into play. Gift provisions will come only in case where it is transferred between a related parties. But however,
I'm a non-resident. I worked in India for 10 years.
I have a very loyal servant. I feel that I'm going back to my parent country. I feel that my shares, I want to give some percentage of my shares to this person for his loyalty. Is it allowed?
Got it, sir. So generally, it will be coming in the income tax angle also, where the tax will also be payable in India. Okay. So generally, from the FEMA angle, I need to check this point whether non-relative gift is allowed specifically or not. But it will be anyhow getting caught from the income tax angle, where you have to pay the taxes in India.
Whether it is a gift or a sale, you need to get it valued by your chartered accountant.
Yes. No, it is all different. Either chartered accountant or either SEBI-registered merchant banker or registered value. Which transaction requires whose valuation certificate is important. Even cost accountants are also allowed now for giving valuation certificate for certain kind of transactions. Yes, sir.
So income tax, yes, he has to pay. The recipient has to pay. And the thing is whether he is allowed to gift.
So law clearly,
He can
I will check and come. But law clearly says gifting provisions are allowed. That is from non-resident to resident. Now I need to check whether only it is restricted to relatives or whether it is restricted also given a special permission to non-relatives also. Yeah, sure.
Sir,
Yes.
want to know in case of gifting from non-resident to resident, if they are relatives also. Apart from the share transfer form, there are no compliances involved with regard to FEMA, right?
When you file annual forms, in that time the change in shareholding pattern will be coming.
Okay.
Second, since it's a transfer from non-resident to resident, FCTRS also will come into play because it's a transfer of the shares.
But without consideration, there is no.
Yeah, that's fine. That is fine. There's an option where you can mention as a gift, and then you can file that FCTRS form. So basically, reporting will happen. There's no specific permission required. Reporting will happen through FCTRS form and also through the annual reporting of the company, which will be doing through FLA returns or APR returns. So in that, you will mention the change in the shareholding from non-resident to resident.
So it has to be mandatorily filed.
Yes.
FCTRS.
Yes. So yes, if it is from non-resident to resident, if it is a transfer of shares, then yes, definitely you need to file FCTRS.
Right. Between non-residents, if there is a gifting, then there is no filing involved.
Between non-residents?
Yes.
Yes, then it's not required.
Not required.
Yeah, not required. Because already when the shares were issued to non-resident, either FCGPR or FCTR would have been filed.
Yes.
Now when the non-residents are transacting between them, then it's not required. But that change in the shareholding, change in the shareholding anyhow will be reported only at the annual level, at the balance sheet level. That's it. But reporting aspect will not come from non-resident to non-resident. Yes.
The FCTRS form will be filed by that non-resident person or will be taken by the company? Company need to file or that non-resident?
No, the resident has to file.
Resident?
Yeah,
Okay.
so Indian resident has to file.
Is the recipient of the shares?
Yeah, the recipient of the shares. So FCTR is between the transfer of shares which will be filed by the recipient of the share, that is the resident.
What is the time frame?
30 days, sir, from the transaction.
If a non-resident transfers his shares to his wife and daughters in India, so actually it's a demat form, it's been completed. So within 30 days the...
Demat means it is a listed company?
A non-listed.
Non-listed company, okay.
So is it required to be filed for demat accounts?
Demat accounts, I think a specific exemption was given for demat accounts alone. Whether it is only for listed or unlisted, that I will just check, sir. But a specific exemption is there for demat accounts for not filing of these forms. Because it is happening through, whether it is through demat or whether it is through recognized stock exchange.
No, it's a non-listed company.
Okay.
But the shares are being held by one of the promoters. So he gifted his shares to his wife and daughter and sons.
Okay, got it.
Part of it. Part of it.
Got it, sir. Maybe I'll just check this point, sir, whether through demat account when it is transferring, whether this FCTR is allowed or not.
This was done about 3-4 months back.
Okay.
So that's why you want.
But AD bankers, okay. How did the funds go?
No, it's a gift now.
Oh, it's a gift. Okay. Okay, sir, I'll check this point and I'll come back to you.
If there is any penalty for late filing of FCT, if at all.
The late submission forms are there, which I told you, 200 rupees per day and the fine.
Who will initiate that? The company has to initiate or the recipient will initiate?
No, it is the recipient, because he is the person who is transferring the, who is receiving the shares. No? So the recipient has to initiate. So the person who is there in India. So one basic rule is, the first condition will be applied, or the first liability will be applied to an Indian resident or an Indian person. So either if it is an Indian company or an Indian resident. But whether it is applicable or not in your case, that I will just check, sir.
Okay.
So maybe we'll quickly also look at the new regulations which has come for the overseas investment, okay, the ODI part. So in 2022, this overseas regulations and overseas rules which has came, overseas investment rules. So what it basically says is, any investment which you are making outside India, okay, it has to be categorized in two segments, okay. One is with regard to, these are the definitions, okay. One is with regard to whether it is a financial commitment or not. Second, whether it is an overseas portfolio investment, okay. Both clubbed together will be regarded as an overseas investment, okay. Now, what do you mean by financial commitment? Overseas direct investment, that is the ODI, which is generally happening across the industries, will come under financial commitment. Debt will also come under financial commitment, and non-fund facilities, this is very important. Any person giving guarantee, okay, for a third party, that also comes as a financial commitment only, okay. That also will be regarded as an overseas investment, and the schedule conditions of that particular overseas investment should be checked. Now, if you look at basic definition of ODI, now when we see in the previous slide, financial commitment plus the overseas portfolio investment equals overseas investment. Now, what do you mean by financial commitment is ODI, debt and non-fund facilities. Now, what do you mean by ODI is very important. ODI is basically by way of acquisition of an unlisted equity capital of a foreign entity. Anything which is unlisted equity of a foreign entity will be regarded as an ODI, whatever percentage you invest in, okay? Or subscription or memorandum to any foreign entity. It is talking about foreign entity and not foreign company. Foreign entity means anything like, let's say, trust or any partnership entity or any entity where you are subscribing or as a partner for. If it is a listed foreign entity, then more than 10% will fall under the bracket of ODI, okay? Now, the same listed a foreign entity whose equity shares or any other fully and compulsorily convertible instrument is listed on a recognized stock exchange, which is more than 10% investment, will fall under the bracket of ODI. Now, very important, if any investment with control where investment is less than 10% will also form part as an ODI. Now, what do you mean by control, or how you can see the control? So the control definition also clearly explains the right to appoint majority of directors, to control management or policy decisions exercisable by a person or persons acting individually or in concert, directly or indirectly, okay, including by virtue of their shareholding or management rights or shareholding agreements or voting, okay. That means even though if you are not investment anything, but through your agreement you are able to vote at the shareholders meeting, then that is also a control. Agreement that entitles them to 10% or more voting rights in any other manner in any entity. Let's say compulsorily convertible entity, or a contract saying that you can get 10% holding in any other third entity if you become a controlling manager here. Then that third entity also becomes an ODI investment for the first Indian company, okay. So this is also very clear, once an ODI, always an ODI. Even if it is falling less than 10% or you are losing the control part, unless it is disinvested completely, it will be always a part of ODI. The form which has been changed with this 2022 year is, first it was required to be filed, form ODI was required to be filed. Now it has been changed to form FC. So very important aspect. Now if you just compare the previous form and the new form, it clearly has lot of line items for non-fund based commitments also. That is a financial commitment. Whether you are a guarantee or another person is also there as a guarantor, okay. All those conditions are also there. So now this form FC is required to be filed. And one of the practical experience while filling this form, which I have personally noted, is RBI is very cautious with all the columns. They will not allow you to leave any column, okay. If that column is not applicable, you have to mention specifically not applicable in that column. If that column, if the column has, let's say it has 10 options on investment, and if only one option is available, then you need to strike off the balance 9 options and then tick on the one option. So this is the level of scrutiny which the RBI legal team does. They do not leave any scope of change in the this thing in future as well, right? So you need to be very careful while filling the forms also and mentioning the proper details. If anything which is not applicable, you just cannot leave blank. Okay, you have to mention not applicable or no very clearly. Now, what do you mean by overseas portfolio investment? It is falling again in 3 conditions are there. One is it should be other than ODI in foreign equity securities, okay, but not in any unlisted debt instruments or any securities, because whatever you invest in unlisted will be regarded as an ODI. Other than ODI means less than 10%, okay, and as I mentioned, if it is in unlisted, it will be regarded as an ODI, okay. Now this is a summarization of what we have already discussed. Now very important section. So with this, I think penalties is there, then the forms are there, and what are the opportunities where we can, as a chartered accountant, we can dwell into. Only 3-4 slides are there. Penalties. I was going through a couple of my clients' details in terms of how RBI is looking into the matter. Okay. As I was also discussing with a couple of you in break, RBI is always seeing us in a default case. It is not an income tax law and GST law also. There is some scope depending on the officer that okay, we can get a view that okay, we are good, but some error has happened. RBI law, whatever you have done, it's error or anything, you are in default. You have to prove it to RBI by any means, by saying that okay, we are unaware of the facts, or we are filed it wrongly by some or the other means, and this is that. So the penalty, and this can be interpreted from the section of penalty also, which the RBI is imposing. So the penalty section reads, I'll read that's why I've given the section itself. If any person contravenes any provision of this act or contravenes any rule, regulation, notification, direction or order, anything if you contravene, issued in exercise of the powers under the act, or contravenes any condition subject to which an authorization is issued by the RBI, okay, shall upon adjudication be liable to a penalty up to 3 times of the sum involved. It is not taxes, or it is not amount of the sum. It is 3 times of the sum involved. If you have invested 1 crore rupees, the penalty itself is 3 crores. In such contravention, where such amount is quantifiable, or up to 2 lakhs where the amount is not quantifiable, but if it is of a continuing nature, then the penalty can be extended up to 5,000 rupees per day. So this is the level of penalty what the RBI is issuing, and the impact it will have on the clients. So it is very it's very confusing. First, the act itself is not clear, which section or which regulation is applied. Amendment comes as regulation, directions, notifications, act and everything, where it says that no, you have to follow this because I have already issued a notification. It is coming from a press release which is given in the regulation. So you have to see all those things where it is not clear. After fighting all those things, if a client is having that courage to invest, and if he gets into any error, the penalty can be up to 5,000 rupees per day of the form not filed or any error which is a continuing nature. So that is the level where caution is required, or where we need to be very careful in terms of giving any advisory to our clients. We need to be very cautious in checking all the angles of the RBI rules and regulations, and to give a sense of relief to everyone here. The best the procedure which we also generally follow is going through the reverse way. Check the compounding orders. Check the compounding orders of that particular say. Let's say, sir, for your example, you had that gift example, right? We'll be having some compounding orders where whether this gift is, whether FCTR is required for that particular gift giving to a relative or non-relative. If you go from that angle, we'll be able to understand that what is the interpretation of RBI and how the RBI is looking at this matter. Okay, so this becomes a kind of relief, and compounding orders are available on the website itself. It is like year-wise it's given. So whatever is the transaction or whatever, we can maintain a proper database and see that okay, for this particular law, this is the compounding order, and when any transaction of our client comes in, we can go from the reverse way and then read the law and then give them the proper opinion. Like I also recently saw that I was also mentioning in our SSP portal, okay, if you just log in, I saw 2 days back. On the right side top corner, one highlighting link is coming. If you click on that, it is showing where the CAs are required to see regulations, Prevention of Money Laundering, Black Money Act, FEMA Act, all the things are compiled and it is being given in the SSP portal itself. So that means from all the angles, even the institute is telling us, okay boss, be careful, all these angles are coming into play. It is always better to take caution and read from all the angles and then give an opinion to the client. So this is the level of penalties which is there. And now, yes, very important. Now when the penalty is levied, what to be done as a professional or as a client? We can go for compounding. Okay, compounding is basically going to the RBI and telling, yes, I have done a mistake, please forgive me, please don't levy such a big penalty. I am what to say, a small person, a poor person, I cannot afford all these things, please help me out. RBI will give you that relief in terms of reducing your penalty amount, which they can even reduce it to 10,000 rupees in total. Okay, if the error is so minute or so this thing, then they can even reduce it to 10,000 rupees. So 2 of our clients have recently got a penalty order from 10 crores to 1 lakh rupees of penalty because of the small error. Okay, 10 crores is based on this slide and 1 lakh is based on this slide. So that is the impact of creating a compounding order. Okay, so that is that relief is given by the RBI, because RBI is saying we will not harm genuine cases, but we will not leave the other cases. So that is the interpretation what RBI is giving it. Now, what are the different forms which we need to file? Okay, there are form A1, A2 is there, it's generally for remittances. Okay, FCGPR, very important. Whenever there is FDI inflow in India, and when the company is giving any shares or issuing any shares to a non-resident, form FCGPR is required to be filed within 30 days. The same is form FCTRS when there is a transfer of shares between residents and non-residents, right? Then in that case, form FCTRS is required to be filed. Form ODI, which is now being shifted as form FC, okay, for any investment you are making, overseas direct investment. Okay. Form FDF is for shipping documents. Softex is again for declaration of your software exports. Okay. Form ECV, very important. This is also very, because parent companies, when they are outside India and they want to fund that subsidiary companies, ECV will be given by those parent companies in the subsidiary, external commercial borrowings. So that particular form is a separate form which will be also filed by the client. And all these forms are required to be filed through the AD bankers only. We as a customer or as a client or as a consultant cannot directly go and knock the doors of RBI like how it was used to be before. Okay. Post-COVID era, within the department itself, we are not encouraged. All the communications to the RBI can only happen through AD bankers now. Okay. Now the AD bankers is the only medium of channel for discussion between the RBI. But the tragedy here is AD banker is not aware. So as a consultant, we have to be aware and we have to educate the AD bankers sometimes. Okay? Like some of them are mentioning, AD bankers tell us to mention the purpose code, which is actually not the nature of the service. But we have to tell them that no, this is only because AD banker will think from that angle. They want to just get the approval from the RBI, and they know that if you mention this purpose code, approval is getting at a very rapid pace. So they will just tell that boss mention this purpose code and close it. But at the time of disinvestment of the asset in India, when you are taking back or repatriating back the money, that time the problem will come. That time they will check the complete angle of it. At that time of investment, you have mentioned a wrong purpose code. Now you cannot invest it because this is not the investment for which the disinvestment is happening. So you need to be very careful and check the end part of it. It is just a small thing. Purpose code mentioning is just a small thing, but it will have an impact at the time of disinvestment. Okay, so form ECB also is very important. FLA returns and APRs returns, the annual returns which the companies has to file for any change or any or intimation of the foreign assets and liabilities. Okay.
No, this is FLA is applicable when a foreign you make a ODA.
ODA, yes.
An FDI is signed.
ODA.
No, if you have non-resident shareholder holds shares in your company, then also you are supposed to report it every year?
Sorry sir, non-resident?
Suppose if a overseas entity holds shares in my company,
Should I report in FLA?
Overseas and yes,
Yes. Okay.
It is basically sorry?
FTA and ODA.
Yes.
Okay. No, go back to the previous slide.
This last
See, the last one and the earlier one are the same.
Same. Actually, by mistake I have mentioned it. So now very important and very interesting slide. What are the
question?
Yes.
This GPR, whether it is required, when it is a non-repatriable basis. When the investment is made on non-repatriable basis, whether GPR is required.
Yes, sir, required. Because it is a reporting requirement. Even though if you are not going to repatriate the amount in future, you need to report it that this investment is coming on a non-repatriable basis, and GPR requirement is there.
But it was done long back, as you said, the compounding and all those things.
Yes.
The RBI is not coming forward to answer at all. But by this time, the person who has invested, he wanted to get back the money.
But okay. But if it is a non-repatriable basis, how will he going to get back? Is he going to get back through dividends or?
Like invested long back and.
Whether invested in shares?
Invested in equity shares or private unlisted company.
Okay, but after the amendment now, if it is invested as a non-repatriable basis, you need to compulsory change it to repatriable basis, or you need to disinvest the shares. So currently, if you are investing in a shares, at a general overview I am telling, it is not allowed to hold the shares on a non-repatriable basis. You need to compulsory disinvest.
On repatriable basis, let us say now the Indian person who is acquiring, he is acquiring by giving the money, remitting the money to NRO account. So NRO account is going to repatriate by chartered account certificate by paying the income tax and everything. So nothing wrong in putting the money, acquiring through NRO account.
Correct, sir. But again, if the reporting is not happened in the first place itself, the FEMA provisions will be coming into play.
My interpretation on this matter is GPR is looked into because ECB is allowed when a person is invested more than 25% in an equity.
Foreign direct investment.
ECB, a person can come with his individual ECB.
Correct.
If the investment is made, so in order to reckon it is 25% above, GPR is more relevant, more important. Otherwise, when it's not looking for non-repatriation basis, it is all right to leave it like this.
Correct.
That's my interpretation.
Correct, sir. If it was invested long back, previously this form A1 and A2 was there. In that declaration was also there that whether this investment is there on repatriation basis or non-repatriation basis. So if you can just check that whether that form A1, A2, whatever was applicable at that time, whether that was filed or not. If it is prior to if it is long back, in that if it is clearly mentioned that it is of a non-repatriation basis, then that is well enough, sir. Then this form that
A2 is only for remittance outside only. A2, form A2.
No. That time, I'm sorry, not the form A1, A2 I'm telling. When investment used to come in India, a declaration was required to be given in a specific form. Okay, at that time an undertaking was given by the foreign entity saying that it is on a non-repatriation basis. Whether that declaration is given or not, if that is given, then it is well within the ambit of the law. If it is not given, then you need to compulsory file form SCGPR.
Or at least in FIRC it should be mentioned.
No, FIRC is just information about the funds coming in from NRO account or whatever it is. But this declaration is a specific declaration which we have to give.
Thank you.
So this is the slide which is more relevant to us in terms of professionals, how we need to deal and what are the opportunities available when we are dealing with the FEMA practice. So first is the advisory part, as you have rightly seen. As a consultant and as being in the profession and in the fraternity, when we are seeing such a vast law with such amendments and regulations coming into play, it becomes very important and an opportunity opens up for us to give an advisory to the clients because they will not be aware of all the provisions. So that is very important. Second is the compliance management. Even though only the AD bankers are required to submit the forms and all those things, still the client is not aware on how to take this forward and whether the AD banks, the unawareness of AD bankers also gets a trust issue with the client. So we can play a role as a consultant and guide the AD bankers as well as the client to properly file the forms and then mention the proper purpose code and everything. Next is the certification services. FEMA also requires a lot of certifications, including the valuation by a chartered accountant. So that also is a very good opportunity for us under the FEMA practice. Audit and assurance. FEMA also requires a lot of places you will see last audited balance sheet. Okay. So that is required, or some definition also says the audited balance sheet should not be beyond the 6 months criteria or 15 months criteria. There are different places where different audited balance sheets are required to be done. For the purpose of FEMA also, you can specifically do the audit and mention that as an audited balance sheet by a chartered accountant, and you can do the transaction of the other FEMA services. So this also opens up a very vast opportunity. Representation services, as we rightly see, compounding of orders with RBIs and ED coming into play for any other matters. We can represent very well to our clients. Trainings and workshops, okay, for always updating to the clients on what are the amendments which is there. It also opens up a bucket of giving a lot of options and trainings to them. And this FEMA compliance, again, I think it's just a repetition of what are the compliances. So most of the questions you already answered it, so I think I'll just leave up to this. One important question is so this I'll just go through one so that it will be summarizing for us. How can immovable property be acquired outside India by a resident? Okay, immovable property can be acquired outside India. A person resident in India may acquire immovable property outside India by way of inheritance or gift or purchase from a person resident in India who has acquired such property as per the foreign exchange provisions at that time, which was there. Okay, a person resident in India may acquire immovable property outside India from a person resident outside India in these scenarios: by way of inheritance, by way of purchase of out of foreign exchange held in the RFC account, okay, by way of purchase out of remittances sent under the LRS transaction, okay. So this is very important when we are talking about the immovable property purchase by a resident outside India. And we have already seen this. Can foreign embassies and diplomats purchase a property in India? So then yes, it is allowed if we get a clearance from the Government of India, Ministry of External Affairs, okay, for such purchase. And the consideration for acquisition of immovable property is paid out of the funds from abroad through banking channel. So this is also there. And this we have seen. Can foreign nationals acquire property in India? Citizens of Pakistan, Bangladesh, Sri Lanka, Afghanistan, China, Iran, all those, irrespective of the residential status, cannot, without prior permission of the RBI, acquire or transfer any property in India, okay, other than on lease, not exceeding 5 years. So for these countries, the lease is only 5 years which is allowed. This provision shall not be applicable to an OCI. If he is an overseas citizen of India and also citizen of any of these other countries, still he will be regarded as OCI and you can very well purchase the property, as we have already seen. Foreign nationals of non-Indian origin resident in India, okay, can acquire immovable property in India, okay, but in what scenario? Foreign nationals of Indian origin resident outside India can acquire or transfer immovable property in India on lease, not exceeding 5 years, and can acquire immovable property in India by way of inheritance from a resident. Okay, so these are the criteria. All other acquisitions, transfers by foreign national will require the prior permission of RBI, which the RBI generally does not give. But in law, it is there. We can get a permission from RBI. Okay. So this is with regard to repatriation of the sale proceeds of immovable property. So yes, I think I'll just take the questions from anything is there from the audience, and then we'll close it.
Can you elaborate the current account and capital account?
Okay, so I'll just summarize quickly. Current account transactions is basically your day-to-day transactions, which is generally an exhaustive list given by the RBI. Current account transactions are generally allowed unless specifically it is prohibited. The list is given in Schedule 1, 2 and 3 of Section 4. Okay. Now coming to capital account transaction. Capital account transaction is given in the Section 5. That is generally not allowed. It mostly deals with assets, liabilities, investments, okay, securities and all those things, whereby the permission is given only in specific scenario. FDI, ODI all falls under the bracket of capital account transaction, whereby the permission is given through the rules, FDI non-debt instrument rules, where schedule 1, 2, 3, 4 are different are there. If any person resident in India, any non-resident or a foreign entity investment in India is there, then in that case we need to follow the schedule 1, 2, 3 rule, then only it is specifically allowed. The difference between current account and capital account transaction in general is there for the LRS limit, what we generally see. LRS 2,50,000 USD is generally allowed to be transferred freely. That is for the purpose of current account transactions. Okay, that is generally allowed, and the limits also are given. If it is exceeding that limit, then only you need to go and search for the permission from the RBI. Whereas for capital account transaction, unless specifically it is given approval, even if it is 1 rupee investment, then only it is allowed, or else it's not allowed. Let's say in financial services segment you cannot invest, okay, and even if it is less than 2,50,000 USD. So all those conditions will come under capital account transaction. So the difference as such is not required, but we are required to learn the difference between the two because the conditions are different for current account transaction and capital account transactions. Yes.
So the foreign direct investment that you on the listed companies 5, 10, 24% and you put in that as an investment in unlisted company.
Yes, correct.
So private company comes as part of the unlisted company.
Yes.
So if you are an NRI, you are able to invest in NLP without any issue. You are able to invest, even do your own business without a sole proprietorship form also. But for private limited company, you cannot invest.
No, you can invest, but the procedure has to be followed where form FDI has to be filled and through the AD bank. Yes. You can invest, very well invest. That 5%, 10% is given for a blanket approval, where you don't have to get an approval.
But for private company, it's any investment you have to see.
Any investment you have to compulsorily see the sectoral caps of the FDI, and then if any performance conditions are there, you need to see that. Those conditions and sectoral cap are also applicable for LLPs or partnership firms in which you are investing.
So if it's within the sectoral caps, we don't have to find any forms?
No, in that sectoral cap schedule itself, you can see the general, the provision is given whereby permission is given, whereby RBI says if it is prohibited or not, and if it is general permission is there, it will be given as general permission. Yes, sir, please. One second.
My client runs a commercial real estate sector. It is a mall in India.
Commercial real estate? Okay.
Basically mall. So can he take investments from foreign nationals by way of partial stake sale? Or can he take any debt from by way of ECB?
ECB is allowed, sir. That is, ECB he can take it from debt from outside India, whereby master direction of ECB is given. If the ECB is coming from a foreign direct shareholder, that is blanket allowed. If it is coming from any other person, then we need to see the conditions, the minimum average maturity period and the amount which is coming in. All those conditions are given under the ECB guidelines. So ECB is very well allowed. Whereas now if you are telling funds, if you are getting from outside India as a share capital, then in that case that will be regarded as an investment in the real estate business. Then we need to again go back to the definition which we were discussing on whether the real estate business investments, whether this particular commercial site is falling under the bracket of real estate development businesses. Here what the definition clearly gives a differentiation is if it is for the purpose of building a commercial or a township, okay, then it is allowed. But if you go to the AD bankers for this particular thing, AD bankers will not have any reference for it because it is a newly come differentiation. So what generally we follow as a practice is we go for the RBI for an approval. RBI has to interpret it. RBI can come back to us if they are not having any particular investment in that, because generally what people also do, they invest it as not as a real estate business. They bring in money or invest it as a general or corporate purpose. That is one common which is used by the AD bankers. So even if you are bringing in funds through ECB, if you mention as a general or corporate purposes, okay, because you are using that for the business, okay, RBI will give an approval to you blanket. The only crux here is when the definition of real estate is not clear, we are not going through the route of real estate investment, but we are going through the route of general and corporate purpose. Now here the problem will come is you need to give a clear indication that this investment is for the purpose of general and corporate and not falling under the bracket of real estate investment. So that differentiation, if you are able to give it and bring in the investment as general and corporate purpose, it is generally allowed. But for the purpose of real estate, I still have a litigative stand on this case. The real estate business will not have a clear, will not always have a clear interpretation. I would suggest that we can go for an approval from RBI so that tomorrow it doesn't have any problem for us.
Okay.
Yes.
There is a transaction where the person he sold the property. Proceeds have been transferred to his own. Yeah. He sold the property, and the proceeds have been transferred to his own NRO account. By the buyer. He transferred to the seller's NRO account. Now the seller, he wants to transfer his funds from NRO account to his NRE account.
Okay.
So the banker is requesting 15 CB for this transaction.
Okay.
So like he is transferring from NRO to NRE.
Right.
So whether 15 CB is mandatory or
as per the transaction, since it's a transfer from NRO account, it gives a justification or a thing that whatever income you have earned in that particular account, it is you are transferring that money outside India. Okay. For general purpose, any transfer from NRO account to NRE account to outside India, 15 CVs are given normally. Okay. But here you are telling it is a transfer from NRO account to that person's NRE account only. Okay. Then I think it is just for the purpose of documentation for that particular bankers to see from all other angles what we were discussing, that it is allowed as a FEMA practice or whether TDS is applicable on that and whether TDS is paid, because it's a same person's account transfer. Okay. My interpretation on this is, as per law, 15 CB is not required because there is no income which is getting chargeable tax, because it's the same accounts transfer only. However, bankers generally want that because of that particular documentation. We have also faced this issue and we are also issuing 15 CB with clearly mentioning the point in the remarks, saying that okay, this is for the purpose of the same transfer account, but only for the purpose of initiation of the funds from the bank.
Banks are asking if I purchase, I am in SEZ, I am purchasing goods from another SEZ, they are asking 15 CB.
Okay, so sir is saying bankers asking if they are purchasing goods from another SEZ and they are also in SEZ. So please give hints.
No, they are proposing to amend a lot of SEZ rules. The key action points are
Yes.
mentioned.
So I think I'll request ma'am to have one session with AD bankers also, so that we can put up all our questions to them and let them also answer from their side why they are asking all these questions. Because when we interact with AD bankers, they just tell, we just need for our documentation, sir, sign contract. So that is what is their thought process is. But beyond that sign, we know what is the implications and how it can backfire on us. But we cannot do anything, sir. Simple is business panno, so we have to.
In those cases, if you say it is not required, they give copies of 2 other FCBs issued by chartered accountants.
Correct, exactly.
So we are not able to defend ourselves saying that we are not.
Correct. So I think as a fraternity, we have to go and give representation
I
to.
think it should come out with a guideline, guidance note on this 15 CB. Now it has become more relevant.
Yes.
I think that they should come out with that. So it's easy for us. There should be uniformity in overall approach.
Yes.
So this LRS that we spoke about, the 250,000. So if there's somebody, a resident in India who's want to help their non-resident right outside, mandatorily it has to be transferred outside by the resident, or there's any way that that resident can actually credit into the NRE account following whatever forms that we have to follow?
No, it can be credited to NRE account. The NRE account's permissible credits allows you that. So any LRS limit also you can credit in that account. So that is okay.
Sir, can we discuss some IDBMS issues? Because what happens is that my friend's company, they have made some foreign payments, making some deductions for credit notes and quality rejections. Now the AD banks are saying that you have to make these payments in full and get it reimbursed.
Sorry? You have to?
See, suppose if I'm supposed to make $10,000, I deducted around $2,000 for quality rejections and credit notes, because they issued a credit note because of pricing differences. honestly, I don't find a reason why it should not happen, because credit note means for the customs purpose, you have paid money on the higher amounts only, you are not paid on the lower amounts. So ideally, there should not be any problem, but the bankers are saying, no, you make the payments to your overseas vendor in full and get it reimbursed from them. How is it possible?
No, generally, if you look at the export of goods and services, that
I'm making an import payment.
Okay, import payment. Okay. So it is for the quality purpose. Are you
quality and rejection? Quality and correct ones.
Are you sending back the goods?
No, we are not. We are scrapping it here.
So then in that case, I think there's still a litigative issue here. If you're not sending back the goods, the bankers will not be able to map that particular in that portal. So that's why either it is important for either to send the funds back or the goods back. Now if it is getting destroyed here, then I think a separate procedure is given under the customs.
No, they are saying that you need to get a quality inspection certificate,
exactly.
Something like that.
Yes.
But I can understand for quality payment. Suppose because what happens is that the metal prices are very volatile. See, today it may be $50, but because of fluctuation of it may drop to $30 as well. And your vendor may genuinely give a credit note.
Correct.
But even in that case, the bankers are taking an exception. They are saying that it's not allowed and we are not supposed to deduct this.
Maybe I'm not very sure on this procedure aspect, but I'm sure that if the goods are not going out or the funds are not going out, either one thing should happen. If it is not happening, then there's a separate procedure whereby you
when a mail from vendor saying that this is for a genuine purpose, will it suffice?
No, sir. That will not suffice for sure. You need to have a separate procedure for this. I'm not aware of the procedure, but there is a procedure separate. While if any imported goods are there for which payment is not made or not sent back, then it has to be discarded, or the reason for this has to be paid. You can very well tell if you have got for sample basis example. So all those things are allowed. So there's certain conditions it is allowed. If you are getting the goods only for repair and maintenance purpose, but you have to again send back the goods. That is the major condition. If those things are not there, then these issues will come. But prima facie, yes, the bankers are somewhere right in terms of getting some document for that purpose.
So can we apply to the RBI, because when we went through the Master Circular, it says because up to 5% bankers, EAD banks have the right to do that.
Exactly.
Anything above 5%, they are saying that you can write it to the RBI. But the bankers
what RBI will tell, if it is less than 5%, you go to EAD bank and convince it.
No, they say that if it is above 5%, you have to apply to the RBI. That's not what they say.
Correct.
But the EAD banks are saying no, RBI will not. They will take more than a long time to. They won't even clear. They will make your life hell.
I think all EAD bankers have one WhatsApp group, and every day they message. Today we will tell clients this line. RBI will take long time. RBI is not available.
But the procedure is available. No? You can still apply to the RBI.
Yes.
And it is the RBI's purview to either accept it or reject it.
Yes.
It is on the client or the EAD bank. Well, should the EAD bank go to the RBI or the client should go to the RBI?
EAD bank, sir. Everything should happen from EAD bank.
So EAD bank has to apply to the RBI.
I think it's time for lunch, and we have last question. Last question.
The banker told me that once this money is transferred from NRO to NRE, he loses the control of that money being taken by the correct? Is that right?
Yes, because
so
NRE
that's why he
account,
was insisting on 15 C.
Yes. Because from NRE account you can transfer the funds easily. So that's why this issue is. I think we'll take the last question. If anything is else there, we can take after the session. We'll take after the session because speaker and the lunch time is also.
People are ready for food for thought only.
I'll be available now, so we can take off the.
Yes, one last.
Yes.
What is the consequences for a non-utilization of ECB by Indian company within that stipulated time?
Consequences are there, sir. The conditions is penalty. I mean, the conditions are there, but you can always have an addendum to loan agreement whereby you can amend the clauses and file a revised ECB form. So that is what will be also appreciated from the banker side also.
That too completed. Even after executing that addendum agreement, that still they are not able to apply that amount.
Then you can very well extend that, sir. That extension is allowed. So it's not restricted to only one addendum. So you can always file revised ECB forms and you can get.
Sir, buyer's credit doesn't fall under ECB. Suppose we take a buyer's credit for import credit. Will it fall under ECB or?
No, that is a trade credit.
Sir, any additional disclosure or requirement in ECB2? As a chartered accountant, we are signing that ECB2.
Yes, correct.
Any specific information to be given, additional disclosure to be given by chartered accountant regarding that unutilized amount?
Yes, that is actually required. They have that table.
In the table, that unutilized amount is specifically mentioned, and it is also parked in India.
Correct, and the certificate is also offline, so you can very well mention your own points also, and then give a detailed certificate also.
Okay.
It has to be submitted physically only. So that remarks column, even if it is not specifically following any other form, you can very well give it in a certificate.
So we can give it as additional
Yes,
point.
yes. I think we'll take other questions in the.
Thank you.
Thank you everyone.
Yeah, thank you, Akash.
His first session in SIRC on FEMA. On FEMA, and I think he's done a great job. Let's give him a big hand. And he's answered everyone's all the queries which have been raised, and we have our second speaker also here right now. So the sooner we finish lunch and start off, I think we can take up more questions with Sir also relevant to his topics. We've given time till 2 o'clock, but if everyone can assemble here between 1:45 to 1:50, we can start it off. With due respect, I want to keep up to the time zones. Okay. Yeah, very vast subject, and we are organizing a session with bankers, but bankers have their own internal restrictions to come and address here. So the negotiation is no marketing, so we have stopped there.
Without that, they won't come here.
Yeah. Good afternoon, everyone. I think I should thank everyone for actually coming into the hall before 2, and we are awaiting the session to start. So morning was a brilliant session by Akash. We have now one of the senior most practitioners of FEMA CS, TP Sridhar. So request you to please. Many chartered accountants actually consult him, and I think even I reached out to him for a couple of cases, and he is generally very generous in sharing his knowledge and experience with us and clarifying all our doubts. And in fact, he asked us to circulate the Google form and the questions. Sir has the questions which was received on the Google form, and apart from that, I think it will be an interactive session also. So before we move on to the session, I'll give a small introduction of Sir TP Sridhar, who is also fondly known as FEMA TPS. I didn't know that. So he's the FEMA TPS, is a commerce graduate and a fellow member of the Institute of Company Secretaries of India. And he's been in whole-time practice since 2001 as a sole proprietor, providing services to domestic and international clients under company law and foreign exchange. He's been a speaker in various chapters of the Institute of Company Secretaries and the Institute of Chartered Accountants of India on FEMA. He's been invited by banks to handle their pan-India workshops on practical aspects of FEMA and also to share his knowledge and experience to their customers. He specializes in advising on capital structuring, compliances, compounding and matters related to the ED to his domestic and overseas clients, and he also works very closely with clients from US, UK, Japan, Korea, Denmark, Switzerland, Hong Kong, Portugal, etc., who have retained his services for his knowledge and expertise in the specialized field of FEMA. So I think that we are very fortunate that the moment I called and asked Sir, he accepted. He didn't say no, I don't have time. In fact, he gave me a lot of suggestions about structuring this program and also how we could ask participants to send their questions through the Google link so that we can smoothly address all the questions. Thank you very much, Sir. I'm sure that you're going to be asked so many more doubts by all the chartered accountants here, and that we are going to pick on your brains a lot, and we are also going to keep inviting you to SIRC. Thank you very much. Over to you, Sir. Before that, I would like to honor Sir, request Kandarel Sir to come and please honor sir with a small memento from SIRC side. Really?
Good afternoon, ladies and gentlemen, boys and girls. Let me thank the SIRC of ICAI, its committee members and the organizers for having me here for this half-a-day session on FEMA. In fact, ma'am was requesting me to handle a full day session, but two reasons. One, I don't have the energy to talk for 6 to 8 hours. I'm growing in age. Two, I thought there will be an opportunity for youngsters to come in. Rightly so, ma'am was able to pick up an youngster who did a phenomenal job in the morning. So I will be handling the practical aspects of foreign exchange management, more on compliances, filings, the challenges that we face. And probably, subject to time, I want to cover the reporting aspects, maybe on allotment, maybe on transfers. On allotment, maybe we can look at the rights issue, renunciation, declaration of beneficial interest, and transfer of corporate benefits to the overseas shareholder. I think these 3 or 4 areas are the most I wouldn't say complicated. Maybe those are areas where there are a lot of doubts, people keep asking questions and all, etc. And on transfer, yes, eternally there is confusion, eternally, including with due regards to the AD bankers, we have challenges. So I'm going to address only these 2 areas where practically we have issues. I request the audience to stop me wherever they have doubts, wherever I am not clear. Request you to stop me there so that I can provide clarification if I know. In case I don't know, maybe you can share your number. I'll get back to the office, go back to the book, do my homework, and then get back to you. With this, let's start moving. Where do we start? Maybe I see a lot of seniors sitting here. Gentlemen, permit me to be one among you. I feel all alone here. I think I should be down to be here and answer queries and do the lecturing from there. For the sake of beginners or people who are yet to get into FEMA or desirous of getting into FEMA, where did we start? The Act enacted in 1999. FEMA non-debt instrument rules introduced with effect from 17th October. FEMA mode of payment. A person who wants to start maybe will have to read both of them together. Maybe the non-debt instrument rules and the mode of payment and reporting of non-debt instruments. Both are very important. And the consolidated FDI policy. These are the three. And the master directions on investments in India, which is updated till March 2022. So these 5 areas or 5 things we'll have to read. One for a beginner to go through. Once they go through this, they will have broad understanding of what is FEMA is all about. Maybe it is all a small portion of FEMA. The challenge in FEMA is just 49 sections, maybe 7 or 8 chapters. That is not a problem. The issue is where to look for, which rule should I refer, which notification should I refer. Is that notification referring me to some other notification? How do I download? Where do I get it? These are the challenges. You should know where to refer. That is very, very important. Thumb rule. What cannot be done directly cannot be done indirectly. You can't circumvent law. If FEMA says it can be done, it can be done. If it says it cannot be done, it cannot be done. Either it is prohibited or you need to have a prior approval of the authority, Reserve Bank of India or central government, or the case we need to have that. Unless we have the approval, what is prohibited sector can never happen. Where areas are where it is prohibited, it can never happen. You cannot even apply to Reserve Bank of India for approval. But what is not given directly or what cannot be done directly cannot be done indirectly. You can't circumvent law. It's very clear and very settled. Originally, it was test pro regulations which was replaced and the non-debt instrument rules came into force. It was introduced in 2019. April 20, there was a notification which is on land borders. That means people generally say, love thy neighbor. But here, when neighbors want to bring in money, we need to have the approval. Maybe those 7-8 countries from where monies are going to come, in case they come in, we cannot accept it. We'll have to have the prior approval. And it does not stop there. It's more. Rights issue. Originally, when test pro regulation was introduced, the issue of shares, it was very probably for a few months. This rights issue thing was not there in the original non-debt regulations. In I think October 19 it was introduced and April 20 they amended it. I will go into detail. This is where the complication is. And rules are amended from time to time. These are two things, land border sharing and the rights issue, which I want to discuss, share my experiences and maybe quote some case laws also where possible. And any amendment, if you can go to the master directions, you have all the amendments there. See, people ask me about what book to read, what would be the fundamental, where can I get the fundamentals, what are do you have any reference, a good author? I would say that FEMA is like dosa. You will have to take it from the tawa and eat it. Download it from the RBI website whenever you want it. You cannot buy a book. By the time you buy a book and you bring it home and open it, maybe some notification would have come. So the book becomes obsolete. Once they used to say computer, The obsolescence of computer is so high that the moment they write your name and your number in your invoice, that system used to be obsolete because the way it was hardware was developing was so fast. But still worse is the foreign exchange management. Maybe we don't know. Suddenly you buy a book, you say that everything is there. It is 2 volumes costing some 8,000-9,000 rupees. You are so happy, you buy the book, you start reading. The most important chapter what you want would have undergone the change. Some notification would have come. That's it. The entire, probably that particular, at least those few chapters is a waste. So my suggestion here is, you can have a book, nothing wrong. Maybe book is something I believe in reading it physically. So you can read them. But when you want to advise the client, when you want to implement a transaction, when you want to, you see, the best way to do it is download, go to the RBI website, download that particular notification, read them thoroughly, and then advise. Prohibited sector. What cannot be done directly cannot be done indirectly also. That's the thumb rule. But even with the approval of the Reserve Bank of India, the prohibited sector cannot happen because it is prohibited. Lottery business, including government and private online lotteries, are prohibited. That means no foreign direct investments can happen. To go a step further, if you are going to have a company exclusively for creating software for these lottery agencies, even that is prohibited. The state law may permit lottery business. I think Kerala still has lottery business. But you cannot have FDI there. So FDI in lottery business is prohibited. Gambling and betting, including casinos, are prohibited. FDI is prohibited there.
Means FDI is purely a union subject.
It's a purely a union subject, sir. It does not come under the state law. It does not come under the concurrent list. It is a central list. I think it is list 1. Central list is list 1 if I remember right. So they can amend it. Trading in transfer development rights under the real estate business, real estate and construction of farmhouse, manufacture of cigarettes, sectors not open for private sectors like railways, atomic, foreign technology collaboration, any of the including licensing of. So these are the areas where it is prohibited. We cannot have FDI there. You can't, even if you go to the central government, if you go to Reserve Bank or anybody, you will not get the approval. Clear?
Last point. Foreign
Foreign technology collaboration in any form, including licensing or franchisee, trademark, brand name, management, construct, prohibited for lottery business. See, that's why I said, even if you want to provide software services to a lottery business, you may be a software company, you are not into lottery business, but you are. Okay? Abetting crime is also bad. As simple as that. Okay? What are the activities that really requires attention? Rights issue by Indian company. Simple rights issue, you don't have a problem. I don't think you have a problem. Where the simple rights issue should not be a problem. Where the overseas subscriber subscribes for his entitlement. The challenge comes only when he is going to subscribe for more than his entitlement. Then you have a problem. I'll get into that in detail. That's why I said, when the NBA notification came in October 2019, the particular paragraph or amendment on rights issue was not there. Probably in April 20, they brought in an amendment for rights issue. There is a distinction between here, this provision under the Companies Act and the Companies Act. Allotment allotment of shares to a person other than the investor, declaration of beneficial ownership by resident individuals, land border sharing countries. See, these are the 4 areas where we always have some problem with the other. That means I am talking about reporting. We have challenges in reporting, right? I am going to focus on these 4 points and also share with you my experiences on the reaction of AD banks and how it is to be reported, what complications it may have in the future, etc. Let's go into the rights issue. Compliance with section 62 is perfect. You can have a compliance, you issue shares in a definitive ratio. If it is a simple rights issue, pricing guidelines do not apply. We need not obtain a valuation certificate for a rights issue. Within quotes, underline, bold, italics, whatever. There are instances where banks have also asked for a valuation, but a private company or an unlisted public company can determine their price on a rights issue, and valuation is not required for rights issue. Offer shares to non-resident up to their entitlement. In fact, recently, maybe a year back, I was handling a rights issue. The size was pretty large. Everything was, I think they said all the complaints have done, and they said, sir, we have already got some 4 or 5 tranches of money from the overseas investor. Everything is done. Now they wanted to go for a rights issue. I also did not ask them as to how those monies came into the system. Was it the rights or a preferential? I did not ask them much about it. And we started working on it. When the calendar of events was done, and we decided on the dates of when the rights will open and when the rights will close, when to subscribe, etc., etc. I found that none of the earlier FDIs were reported. Meaning, the first condition on a rights issue is to check, maybe as chartered accountants, whether we are in practice or whether we are in employment. The first thing that we need to check is, when we go for a rights issue, whether the earlier FDIs have been reported or not, and whether we have an acknowledgement for that. That is very important, because when we report on a rights issue, when we file the returns with the Reserve Bank of India, the AD Bank will definitely ask us on the earlier approvals to ensure that the reporting has been done and the person to whom the shares are being allotted on rights basis holds those shares and is entitled for those shares. The first check that we need to do is to ensure that we have an acknowledgement in place before we proceed. Renunciation of equity shares by resident in favor of non-resident. This is where the confusion starts. Under the Companies Act, it says, I think 61(1)(3) if I remember right. 62(1)(3), 1A3. The board of directors may dispose them in such manner which is not disadvantageous to the shareholders of the company. This is said under the Companies Act. My interpretation of this is, you can allot shares, the excess or unsubscribed shares or shares that are renounced, to a person who is already a shareholder in the company. That is the intent of a lawmaker. Otherwise they wouldn't have had a preferential offer under the Companies Act. Right? So the intent of the lawmaker is, on a plain reading, the words of law, let's forget the spirit of law. the word of law says the board of directors may dispose of them. I mean them meaning the rights shares, in such manner which is not disadvantageous to the shareholders and to the company. The argument is it cannot be disadvantageous because the money is coming in, and when the money is coming in, how can it be a disadvantage? But the intention of the lawmaker is not that, not to issue shares to Tom, Dick and Harry. The intention is to issue shares to the existing shareholder, maybe in a different proportion. That means using those shares which have unsubscribed, which have been announced, to those people who are not subscribed, who are the shareholders of the company. It cannot be a third party. If it is a third party, then there is no need for us to have a preferential offer, a separate section for preferential offer. So coming back to the topic, renunciation of equity shares in favor of non-resident. So there is always a confusion between when one law says that it can be done and the other law says it cannot be done. It doesn't say it cannot be done, it says you allot shares but go by the pricing guidelines. Pricing guidelines will have to be followed. That means we need to have a valuation report for that. So the challenge here comes when we pass the resolution of the board, when we are not sure about the contribution by the foreign shareholder or the overseas shareholder, whether he is going to subscribe for his entitlement only or whether he is going to subscribe for more. In most of the private limited companies, it's all prefixed. We go for a rights issue, these guys will not participate, we will go for a valuation and allot shares. Because if I go to a preferential offer, then I need to make a hell of a lot of disclosures, compliances, those issues will come. So I'll take a preferential or rights issue route, ask all those Indian shareholders not to participate, get a valuation and be done with it. This is perfect compliance, right? But when it comes to Companies Act compliance, my suggestion here is have a board resolution, because for a rights issue, I don't think we need to go to the shareholders. So it's just a board resolution will do. The board will decide when the rights will open, when the rights will close, and when the allotment will happen. So here, what will happen is, my suggestion is have a normal resolution for like any other resolution on a rights issue. And for the preferential offer, maybe have a separate resolution saying that in case the overseas shareholder is going to subscribe for more than entitlement, such shares will be issued only as per the pricing guidelines, and the board will have the authority to decide on the allotment of shares. That means the price valuation is also taken care. But the issue here is you will have to have a valuation even before you make an offer. You can't have a valuation when just before the allotment. That means when the offer is issued on an application form, you say that in case you are going to subscribe for more number of shares, especially non-resident, the excess amount of shares more than the entitlement will be offered only as per the valuation at this price. Up to your entitlement, you will get at par with all other shareholders. In case more than entitlement, for non-resident shareholders, it will be as per the pricing guidelines. So this offer will have to the board meeting, the minutes of meeting will have to be structured in such a way, or the board will have to discuss this in such a way that normal rights issue will open, and for additional shares, if any, we go by the valuation and have this. Because once you open the rights issue and make the offer, and suddenly you find some foreign shareholders wanting to have more shares. See, practically this may not happen also, because when there is a foreign shareholder, either you have a shareholders agreement or you have a joint venture agreement, you have so many things, so they cannot beat that. But sometimes it may happen that they will want to, the directors or the promoters will agree upon the foreign shareholders bringing in more money because they want money. In such cases, structure your board in such a way that, or the
minutes or the discussions in such a way that you have one resolution only for the rights issue, and second, have a resolution, have the valuation, and have a specific resolution for allotting shares more than the entitlement. Right?
See here with this non-resident, they are existing shareholders.
Non-resident existing shareholders.
So that the rights issues.
Yes, when you go for see, money does not have color, but in my opinion, shares have color, making those shares are whether repatriable or non-repatriable. Right? So the original shares are non-repatriable. If he is going to, and if a resident shareholder is going to renounce it in favor of a non-resident, so the resident share, fresh allotment will become non-resident, repatriable. So when the fundamental share is itself is non-repatriable, the color of a non-repatriable, the add-on to it will not be, should not be repatriable. That is the reason why they want to have valuation term. Okay. Valuation, again, we have off late, I find, no valuation, we have issues. This 90-day calendar, shelf life of 90 days, when does it start? Is it from the date of signing or is it the date of, so that issue, I think off late, some of the bankers are raising. Previously they don't used to see, they look at the date on which the valuation was issued, they close it, they are accepting it. But off late I find there are a lot of queries on that particular area. We will come to it as we see. So, application for more than the entitlement. So, how do we handle this in a FCGPR? Yes, the smoothest way is to have two different resolutions, one as a rights issue, one for more than the entitlement, right? But filing of forms, PAS3 could be a challenge, we may have multiple. So, to avoid that, it's better that we have one resolution. But even in filing of FCGPR, we'll have to file this maybe with a covering letter specifically stating that Mr. So-and-so who was a non-resident and holding so many shares, his entitlement is this much as subscribed, more and about so many shares has come with a valuation price. So in FCGPR you can give the number of allotments, maybe you give the number of allotments there, and if you are able to pass two different resolutions, one for the rights issue alone at par with all other resident shareholders, that resolution will be there, and another separate resolution for the entitlement more than. So this makes life easier. Am I communicating properly on this? Yes, sir.
Even on the rights issue, shares valuation suppose board வந்து டிசைட் பண்றது எக்ஸிஸ்டிங் பிரைஸ் மட்டும் ஃபேஸ் வேல்யூல பண்ணிட்டு இப்போ வேல்யூவேஷன் பண்றதுனால எனக்கு அதுல சப்போஸ் அதுல பிரீமியம் இன்ஃபியூஷன் வரதுக்கு பிரச்சனை இருக்கு. ஸோ அந்த இடத்துல ஸ்டேக் டிஃபரன்சஸ் வரும்ல சார், அந்த ரெனவுன்ஸ் பண்ற ஷேர்ஸ்.
Exactly, sir. The stake differences varu. There will be the equilibrium will get disturbed because through a share purchase agreement or investment agreement or a joint venture agreement, there will be a definitive ratio in which shareholders are going, the resident shareholders, promoters, rather the vis-a-vis or foreign shareholders, it will be there. But in some cases, they will allow the foreign investor to bring in money. Maybe this will be supported by an addendum, they will be supported by some other side letters or whatever. Right? Where it is a family company, the parents are here, the son and daughter, the son, daughter-in-law, everybody is outside India, they want to invest. So they wouldn't mind they investing more. Because I have a typical case where there are 6 shareholders. The parents are here, they had started the company. These children have migrated abroad. So they are slowly they want to convert this to be a 100% foreign owned company. So for rights issue they are authorizing those guys to bring in money. So you are right, this ratio would get affected, but this is again subject to confirmation by the board. See that is on one side of it. The other part of it, how do we sail through this without any issue? Right, you got it? Any other questions on rights? Yes, sir. Yeah. I'm talking about private companies, public companies.
The private company,
shares are allotted to an outsider
Okay.
at a premium.
Okay. Outsider meaning?
Who's not an existing shareholder.
Okay.
With the permission of the board resolution. And with somebody renouncing that they are not making it. So they had the shares and they want to give it to outsider at a premium. Can it be given at a premium at that stage?
No, the outsider meaning whether he is resident or non-resident.
He's a resident.
He is a resident. Sir, see, people, as I told you earlier, people take advantage of this. The board of directors may dispose of the same. That means the board is going in for a rights issue and there are no takers and these shares are being allotted to a person who is not a shareholder.
The point is, since the company has been there for 25 years, there is a value to the company's product and the name standing in the market. A new person is buying it, they will buy it at par in the book value.
Correct, sir.
So they want to give it at a premium.
But it cannot happen through a rights issue. Because then you will not go through a preferential option or a private listing. Right? When you go for a rights issue, the pricing will have to be uniform to everybody. Right? Now, in your case, probably none of the existing shareholders want to subscribe and they want to issue it to a third party. Fundamentally, if you go by the letter and spirit of law, you are defined section 62 of the Companies Act. Because the intention of 62 is completely different. But where you want to allot shares to a non-shareholder, maybe at a price, considering the capital and the reserves, they will have to go through a preferential offer route so that you are able to allot shares at a premium. If it is already done, nothing can be done, sir. But this will be the best option to do it. Okay? Yes, ma'am.
Sir, one clarification is, in case of existing shareholder, he's subscribing to his allotment, plus the non-resident shareholder is also going for additional shares from the existing shareholder who has renounced his right. So to the extent of his original entitlement, he will be subscribing on the par or the value allotted to the shareholders. On the additional amount is as per the pricing guidelines.
Exactly.
So if it is 10 rupees on 10,000 shares, which is his allotment, he'll take on 10. And if it is 12 for the remaining extra, the remaining amount, the extra amount alone will be taken.
At a premium or it will be at a as per pricing guidelines.
Okay, so that is the way he will bring it.
That is the way he has. That's what the FEMA requires. What the FEMA requirement is, when you are going to give shares more than the entitlement, the extra number of shares to a non-resident over above the entitlement will have to be on a pricing guide. Why? What is the logic? What is the logic? Because two things. One, it is a way by which the exchange reserves can be improved, can be better. Because if you have on a rights issue, when everybody is bringing at the same price, you don't everybody because equity shares rank pari passu, interstate. So they bring in more money, everybody brings it at the same price. But suddenly when some foreign fellow wants to bring in more money, that means the exchange reserves will have to be benefited. If I'm not very sure if I can talk to you on this. I mean, especially chartered accountants. The premium brought over and above the pricing guideline by a resident individual. If the pricing guideline is the valuation is 100 rupees and the company issues them at 120 rupees or 130 rupees, that extra 20-30 rupees is taxable in the hands of the company because it is over and above their valued price. But under FEMA, under the Income Tax Act, if you bring it from abroad, I don't think it is taxable. Am I right?
That was changed by last Finance Act amendment.
So that is also taxable.
It's subject to a cap of 10% with a valuation.
Valuation, okay.
Fair market value.
The fair market value, okay. So even that benefit, people are enjoying that benefit. People are bringing large monies at a huge premium from outside. Now that is also getting taxed. Anyways, The Indian law is very simple, sir. Whether I consume, whether I earn, what I do, some sort of tax will have to be paid. You call it service tax, you call it GST, you call it income tax, whatever.
Government is a silent partner to all your activities.
You will have to pay. That's it. Okay, let's not go into that. So, coming back to the points that you raised by you, yes, in case of rights issue, you will have to. That's the whole crux of the whole issue is this. If you are going to subscribe for more than the entitlement, then valuation will apply. At the same time, why this is brought, what is the intention of the lawmakers is that it cannot be at the cost of the people who have invested and stayed in the company for long. Suddenly somebody getting more entitlement and subscribing. No, it cannot happen. In fact, if I go one step further, that's a big difference between 19. Some of senior chartered accountants here will appreciate this. Maybe people who have youngsters who have read 2013 Act may not know this. In 1950s, the Companies Act, the 1950s Companies Act did not talk about all these things. They said rights issue, you give it to anybody. There are so many cases where you go for a rights issue, I renounce it, somebody will acquire. So he becomes slowly the shares get diluted, somebody acquires the share. All these nonsense were happening. And government woke up and said, no, this cannot happen this way. So there's this big change, sea change between the 13 Act, 1956 Act and the 2013 Act under the Companies Act. Okay? So the whole idea here is, next is the reporting. I would suggest that it is better, see, I will compare these reporting, be it whatever reporting it is, be it appearing before filing an FCGPR or filing a compounding application or appearing before the Enforcement Directorate. If your case is very clear, you are able to make the authorities understand the case, the battle is half won. If your handwriting is good, if you are able to underline it, wherever the important points, your 40 marks is assured. That's what I cleared. Okay. So, coming back to the thing. So, most of the cases people don't understand when we file it, because he reads only the computer, he just goes to the monitor, finds out what are the papers, and he is under tremendous pressure because every day he has to keep clearing the forms. So make it as clear as possible. So it starts at the board level, maybe if possible have two different resolutions of the same board meeting. One for the rights, other for the extra renounced shares, especially where it is non-resident. And take it as two allotments and file it on the same day. Maybe the FCGPR could be one. Make out a detailed covering letter saying that his entitlement was this much, he had subscribed for this many shares at this price, and the additional shares at this price as per the guideline was this much. So total amount reflected in FIRs is this much. Make out a detailed covering letter that will communicate that to them clearly. Because every time the challenge I see personally is, every time the form is not put on resubmit board, it is rejected. There are various other reasons why it is getting rejected. Let's not go into that. But under the Companies Act, I don't know about Income Tax Act, but under the Companies Act, the form is put on resubmit mode. But under FEMA, the moment it is rejected, the client becomes panicky. So why sir, it is rejected? It is rejected, you always have an opportunity to refile. You refile once, you refile twice, then your 30 days is gone. You come into LSL. That is it. So today I am talking about an allotment of 4 lakh rupees, which has crossed probably 90 days or because FIRC has not come. That is a poor small company startup. It just started. One of promoter's brother had put in money. I am sure he is going to burn at least some 7,500, 10,000 rupees on LSF alone. So, in presenting your rights issue FCGPR, ensure that whatever documents should be attached is attached, and make out a clear covering letter on the rights issue portion so that it is understood by them clearly. Am I clear? Can I move on? This is the next challenge. How many of you don't understand Tamil here? Happy. பாவம் ஒரு இடம், பழி ஒரு இடம். பணம் கொண்டது ஒரு ஆள், இன்வெஸ்ட் பண்ற ஷேர் அலாட் பண்றது வேற ஆளு. இதுதான் the challenge is here. Many a times group company will bring in money. They say it's a group company, so they have brought it. And allotment will happen to some other overseas company or individual. What is the challenge here? How do we? This is a typical issue that we are facing. How do we do this? Investors and allottees could be different person in certain cases. Most of the cases they will be the same, but some cases it is different. Reporting is mandatory when shares are issued on a repatriable basis. If it is non-repatriable, then you don't have a problem at all. I am happy as long as I get gift from you people, because I am not going to ask any questions, which is non-repatriable, non-returnable. If I get a loan from you, then comes the question, when do I repay? What is the time you will give me to repay? How much of interest you will charge me? What will be the penal interest, etc., etc. There is a big difference between repatriability and non-repatriable. Why a repatriable share is they are wanting to report this? Because you bring in 10 rupees and take away 100 rupees as dividend. Look at it from the exchequer perspective. Look at it from the exchange reserve perspective. What happens? So that is why they want the reporting to happen. So here, reporting is mandatory when shares are issued on a repatriable, that is, repatriable basis. Allottees basic documents like FIRC and KYC may not be available because money will be given by the father and the allotment will happen to the son. I mean the group company will bring in the money and they want you to allot shares to somebody else. They will say they will give NOC. The remitter will give NOC. The allottee will also give you NOC. That's not enough. The challenge is they will ask for a FIRC and KYC, at least a KYC of the allottee. Unfortunately, if my understanding is right, unfortunately the banking practice is such today. The KYC comes only with a remittance along with in a SWIFT code as a SWIFT message. So without getting the money in, without getting a foreign contribution, you may not get the KYC. But for us to report, KYC becomes mandatory. How do we tide over the situation? That means the normal circumstances, the Indian banker or the AD banker will have to send a SWIFT message to the remitting bank or the bank where the allottee has got a shares, allottee has got a bank account, and then get the KYC, which for all practical purposes may not happen. The solution could be ask the allottee to send some $500 or $1,000, get the KYC, return the money within 60 days, done. That's the best way to handle it. That means you need KYC. Without the KYC, reporting cannot happen. But I will not get KYC without the money coming in. That's how the Indian system is.
No, sir, coming to your question.
Yeah.
The allottee sends $1,000. Under what basis can he say that you have received the money?
Sir, he is going to make an application money, sir. He is going to send you application money and the board has got the prerogative to reject it. Very simple. There is no way you can get your KYC. You will have to comply with FEMA.
So first, remit the money as an application money, remit it back, and then do the fresh allotment.
Provided you are able to return it within 75 days. So that is a big challenge. The moment you return it, again, if you don't return it beyond 75 days, you will get greater trouble. The money, whatever has to go back within 75 days.
No, when you return back, will you ready back, but you have a resolution and all these documents to back it up that it is a rejection of application.
That's simple. If you reject it within if you return it within 75 days, the banker should not ask you for PIN CACV. That is the problem. It is not the remitting money. It is not the exchange fluctuation loss. It is the document, the pain of the documentation. So if the return of capital, they will not ask you. They should not ask you. I will not say they should not, they will not ask you. They say they should not ask you, we will have to see. So the challenge comes when the allotee and the remittant allotee are different. And how do I report? And the funniest part is, getting an NOC from a person who is remitting the money is accepted. I am sending the money, I want the company to allot shares to my son, and I giving an NOC saying that I don't have any objection, you allotting shares to my son, is perfect. They are also asking for NOC from the allotee. Right? That means maybe the Reserve Bank of India's way they look at it is, maybe they want an NOC to hold those shares on a repatriable, maybe subject to taxes or whatever. Maybe for that reason, they are asking for NOC not just for the company, also from the allotee, they want an NOC. It does not stop there.
What NOC should the allotee give? See, we can understand if the investor gives a...
His NOC is like an acceptance.
Yeah.
He offers NOC, but he has to accept, no, that NOC.
That is no.
Sir, there's a difference between accepting an NOC, accepting the offer. They want an NOC.
No, what should the NOC contain?
It's a simple letter saying that I don't have any objection in holding the shares for the, or allotting shares in my favor for the money is brought in by so and so. Maybe binomy transfers, whatever. But they want this. The first challenge is the KYC. Next is getting NOC from both. And third is the press note 3 declaration. That means I do not belong. See, in some cases, some banks, in fact the case where I am handling a share transfer for at least 12 different transfers of the same company. I understand the transferee who is abroad, transferor who is abroad, giving a declaration that he does not belong to any of the land border sharing countries. Right? I can tell about myself. I can tell who I am. But they are asking me to tell about the other person also. Being the Indian company is asked to give a press note 3 declaration, or the transferor to give a press note 3 declaration, saying that he is not transferring the shares to a person outside India who is from the city. See, how can, practically if you look at it, I don't see the logic behind why both the transferor and the transferee should give a press note 3 declaration. If the person who is receiving the shares, maybe a person who is buying the shares, maybe if the resident or non-resident, if he gives a press note 3 declaration, saying that I don't belong, or if it is a corporate entity, saying that none of my shareholders, none of my beneficiaries are from a border sharing national, then it is accepted. Banks sometimes ask you for both the press note 3 declaration from the transferor and the transfer in case of transfer of shares. Right? So the greatest the problem comes only when the investor and allottees are different people. Reporting is mandatory when the shares are issued on a repatriable basis. And if you are going to issue shares on non-repatriable basis, you will not have a problem. But only people of NRI and OCA alone can hold the shares on a non-repatriable basis. Not everybody. So if you want to hold if the allottee, the company and allottee are different, or this remittant allotee are different, if it is a non-repatriable basis, you don't have a problem. But there, who can hold shares on a non-repatriable basis? Resident individuals, obviously, you and I are going to put in INR, so there is no question of repatriation there. Other than that, it is only NRI and OCI. Non-resident Indians and person of Indian origin can alone hold the shares on a non-repatriable basis. So for all other purposes, it has to be repatriated. That means where the beneficiary, the remitter and the beneficiary are different, 99% it will be definitely on a repatriable basis, which means reporting becomes mandatory. And the challenge comes on the KYC. So get extra money from them, get the KYC and return. One wine, one free na. Free about a good farm. It's like that. No? You want KYC. So just take the KYC and return the money. NOC from both investors are now this we discussed, and more challenging when the allotee is a non-resident individual. Because there is a if it is an individual getting his KYC through the banker, he giving the first note declaration, all these things will become. That means you will have to do all these things within 30 days. That is the challenge. The timeline. That is the challenge. In fact, in many cases where there is an investment happening in India, there is a joint venture agreement signing, there is a investment, there is a transaction happening. In most cases, the investor will say that all these conditions succeeded or condition post agreement will have to be done within 30 days. Within 30 days, you cannot have all these things done simultaneously. Okay, allotment of shares can be done, transfer of shares can be done, you can appoint directors, but reporting RBI. But of late, I think the system is accepting multiple forms. That's what I was told, though I have not tried. Previously it was only one at a time, but now I think it is accepting multiple forms. Maybe like MCA you can file multiple forms, but I have not tried that. Because they gave a different logic when it was only one at a time. I file one form, wait for it, whether it is taken on record or rejected, and then I go for the second form like that. If that be the case, complying with the conditions succeeded could be extremely difficult, because you may have to file FCTPR, then the FCTR in certain cases, getting through could be extremely difficult, that too within a 30 days span of 30 days. Any questions? Too happy to. This implies two things. Either I am absolutely clear, or whatever I spoke is far above that. I have not communicated it properly.
Sir, so the first line, the investor and allotee could be different persons. Wait or it is allowed? It can be
It is. No sir, it is the right of the investor, sir. Suppose today my son does not have money, so I give him. He is grown up, he is employed. So you cannot people. Similarly, maybe not a correct example, but similarly, the group company has got the money to invest. So they are investing. If you say no, FDI will not come, that part of the FDI will not come. Your reserves will get affected. On one side you are talking about liberalization. FEMA has always been liberalization, and you are talking about ease of doing business. Though in terms of compliance it is not ease. That's a different part altogether. But by allowing this, you are making the investor more money to come into the system. Maybe not, the increase may not be substantial, but there is increase. What you are asking is a genuine thing, I understand. Why allow? But sometimes the investor does not have the money. The person to whom the shares will have to be allotted does not have the money. They expect the group companies to pay for it and allot shares to them. I don't see anything wrong, it's only the compliance. Sir, many a times our bills are being paid by the group companies. We provide services, at least as company security, as chartered account auditors, the payment will have to be paid only from that company. I don't think you can receive your remuneration from some other company or the group company. I'm not very sure about it. You do an audit for X company and Y company cannot pay for it. I don't think that is possible. But for sales and services, the group company pays me, and they say intercompany, they get adjusted. Similarly, maybe group company concept, somebody company investors and their shares are allotted. I don't think it is fundamentally wrong. The issue is only on the reporting. Am I clear? Sir, it is a question of it's the decision of the lawmakers. First of all, let me tell you. You and I, it's only a circle of concern.
Then comes the Binami Act comes in.
That is, sir, that is the reason they want the FIRC and KYC to avoid somebody with that said to avoid Binami or whatever. So the whole idea is when it's a cross border. Why at all they are asking for KYC? Because they wanted to at least the control people are in control want to know. The regulators want to know that to whom the share is being allotted. Because it is not just the allotment today. What is the consequence it is going to have? Maybe several times dividends may go. So they want to have the cake and eat it. That means the money has to come in, even if it is for some other investor, some other beneficiary, the money can come in. But you report it properly, you will not have a chance. Reporting is a problem. It's only an hassle of reporting.
The second part, the reporting is mandatory when shares are issued on
repatriable basis.
That means FCGPR is not necessary when it is not
non-repatriable. Yes.
So this question I was asking in the earlier session. Other gentleman was telling yes, it's mandatory. Was mentioning. I was referring that. I am just again putting the same question.
Sir, if it is non-repatriable, reporting is not required.
That's my conclusion.
That is the conclusion. If I simple things, sir, நீங்க எனக்கு gift-ஆ கொடுத்தீங்கன்னா கேள்வி எனக்கு சொந்தம் நான் ரிட்டர்ன் பண்ண மாட்டேன். நீங்க கடனா கொடுத்தீங்கன்னா 1000 கேள்வி கேட்பேன். கடனையும் வாங்கிப்பேன். எவ்வளவு இன்ட்ரெஸ்ட் எப்போ கொடுக்கணும் 1000 கேள்வி கேட்பேன். So repatriableங்கிறது வந்து கடன் கிடையாது. கடன் மாதிரி தான். So திருப்பி கொடுத்தாங்க. So repatriableங்கிறது கடன் மாதிரி தான். அதுக்கு reporting is mandatory. யார் repatriable? யார் repatriable? Who can have it as a repatriable share or who can have it as a non-repatriable share? Resident individual like you and me can hold it on non-repatriable basis. People of Indian origin, non-resident Indians, people of Indian origin can alone hold it share now because those people are born and brought up in India and they have gone abroad. Or maybe their forefathers were in India and they have gone abroad. So those people will have to be given the liberty of holding the shares on a non-repatriable basis, where reporting is not required. The moment it is non-foreign national or foreign company, then the money comes in only on a repatriable basis. That means the moment it is repatriable, reporting becomes mandatory. The moment you say loan, then repayment period, interest, everything comes into play. The moment you say repatriable, filing of FCGPR reporting becomes mandatory, obvious. Clear?
Foreign investors conflict to invest in a non-repatriable basis.
Sir, foreign investor is a very broad term. Now, NRI and OCI alone can hold shares on non-repatriable basis. Others, everybody will have to send the money back. It has to be repatriated. We don't want foreign. Either his father, he has to be a person of Indian person, or his forefathers should have been here. So, if he is a person of Indian origin, or is a non-resident Indian, then probably the idea there is to look at the lawmaker's intention. Those monies are kept here. They are hoping one day you will come back. Because life in America or Australia may not be all that. Maybe when you are 20s, 30s, 40s, everything is sweet. When you grow older in age, you may not be comfortable, you want to come. So that is probably that is the idea. They are permitting NRI and OCIs to have a bank account here and keep the money returns here. So that you don't have to repatriate. All others, yes, will have to be repatriated. Yes, sir.
Morning we asked foreign shareholder wants to give his shares to an Indian shareholder. Is it possible?
It is possible subject to approval, sir. I mean, see.
He is not a relative. They are not relatives.
Sir, 99.99% the gifting of shares from overseas to India will be subject to the approval. Right? But what the law says is gift of shares of an Indian share being subscribed to a foreigner. That means if I sell the shares, I will get money. I am not selling it, so I am gifting it. So up to $50,000, I need to have a valuation report. Up to not exceeding 5% of the total capital, there is a gifting. There is a separate procedure for gifting of Indian shares by a resident or non-resident. The vice versa also, though I have not actually handled it, the vice versa should also be true. Because it is Indian shares, held by non-resident, which has come on a non-repatriable basis, now is becoming non-repatriable. Still you will have to take the approval. And it is possible. People don't try, but still it is possible. At times we'll have to be paid for taking sugar cane. Very simple. Okay. Clear? Yes, hello.
I have one clarification.
Yeah.
At the time of getting the allotment of shares when he was a resident, subsequently if he becomes non-resident, then you can permitted me to give the shares to the relatives of who are resident.
It's a simple
reporting is required for FCTS.
Absolutely right, sir. Because the person is a resident individual, the shares, the color of shares will be a non-repatriable share. Right? So, it is not going to go abroad.
Subsequently he became non-resident.
The owner became non-resident. But the shares continues to be resident.
This way the law doesn't prevent that for him to give the shares.
Yes, provided it is a non-repatriable. If it is a repatriable share, then the question comes. His doubt is only when the shares are repatriable. The owner could have changed. But the color of the share continues to be repatriable. I think I got an excellent case on when it comes to transfer of shares. In fact, I had to talk to the bankers so many times to convince them about why that FCGPR was not filed. Any other questions, sir?
Actually, I just want to add one more point. Repatriate basis for the individual, why it is important is the cap is there $1 million and above you cannot repatriate. If you have invested 100 crore on a non-repatriable basis, after 3-4 years its appreciation is there for 300 crore. When he has failed to make this repatriable basis, because allotment is done on non-repatriable basis, he is under the problem of not taking, you cannot take the money beyond 1 million based on the allotment.
Yeah, because basically the shares are, if the shares are non-repatriable, you can never take the money outside India.
Beyond 1 million every year.
Sir, there are two different schemes already. You cannot take, but for a different purpose, government allows you to repatriate up to 1 million. 1 million scheme is something different. But this money will have to come into your NRO account, only stay there. And they give you an option. If you want to avail of the benefit, you can avail of this. They are two different. I mean, money is whatever non-repatriable, continue to be non-repatriable. That is it. But if you want to repatriate, maybe under a different scheme. This door is closed. I cannot close this. Maybe there is a small window here. If I want, I can close it. That is not the whole thing.
Is reporting is required for bringing capital in LLP?
Sir?
For bringing capital in LLP, this reporting
Yes,
is
LLP 1 has to be filed. There has to be a receipt. There has to be a valuation. There has to be a valuation.
Foreign and Indian LLP have same partner. So they are bringing from foreign India directly.
Subject to other conditionalities and pricing guidelines, LLP can receive FDI. Yes. Okay.
They are different from partners.
Partner does not matter at all, sir. Partner does not matter. They can bring in the money subject to pricing guidelines and other compliance.
Foreign technical collaboration in holding and subsidiary company. Whether any for that agreement, any uploads are required or royalty foreign technical.
It is, see, when you have a foreign technical, when you have a collaboration agreement, obviously there is going to be a royalty payment. Royalty payment, to my knowledge, comes under the current account. You have a royalty payment, you have an agreement, and month on month, year on year, you are going to pay them. Right? It can be done. You are not allowed. Can I proceed? This is another area of conflict between, I will not say conflict. This is another area of concern or a difference between the Companies Act and FEMA. If you look at FEMA, by and large, the FEMA has been amended to fall in line with the Companies Act. Till TISPRO regulations, FEMA gave us 180 days for allotting shares when Companies Act was silent. And with the advent of the new Companies Act 2013, it said allotment will have to happen within 60 days. And even after that, FEMA was silent. And in 2019, when the escrow regime was replaced by non-debt instrument rules, I think 60 days time came in, and they said allotment of shares will have to be done within 60 days. And they gave another 50 days grace period to return that 60 days in case of no allotment is happening. So it is 60 days plus 15 days, 75 days, the money will have to be returned. Now, the challenge is, Companies Act recognizes beneficial ownership of shares. That means the entire, for the purpose of having a 100% hold subsidiary company and for the benefit of other things or for the purpose of quorum, the Companies Act lawmakers have thought that there has to be a concept of beneficial ownership where the shares are not registered in the name of the investor. That means the investor is one person, but the shares are registered in the name of some other person, and for which he gives a declaration in form MGD 4, 5 and 6. But unfortunately, this provision is not recognized under Foreign Exchange Management Act and the report. In many cases where they want 100% wholly owned subsidiary in India, the foreign company will say that no, the entire capital will be held by them. That means they will have only one shareholder. The purpose, the Companies Act, this thing will get defeated. That means I should have one more shareholder. One thing we can suggest to them is, subdivide the shares, make it 1 rupee shares, let the entire capital be held by them, and only one share of 1 rupee be held by maybe another non-resident or maybe a resident. I am not talking about directors here, I am only talking about shareholders. But many times they don't accept it. They want the entire capital to be held by the company. So the money will have to come from there. While Companies Act is recognizing beneficial ownership of shares, FEMA does not. Then how do we cross this? How do we cross this? How do we overcome this particular issue? Yeah, water here. Very good. It's here. Gentlemen, with your permission.
Joint holding.
Pardon me?
Joint holding.
Joint holding.
First name the individual shareholder, second name the company.
But the benefits will accrue only to the first name shareholder. Tomorrow when that company declares 100% dividend, the entire money will only go to the first name. It's that I don't want that. I don't want that. I want the entire benefits to come to me. You will hold the shares on my behalf, but benefits are to me.
Nominee shareholders.
Nominee shareholders again the same thing. You will have the problem. Even in case of nominee shareholder, you will have this challenge, where it's only in case of nominee you can have a nominee shareholder. One, the overseas company may not accept it because no, they want the benefits to come there. The challenge, the question is not that how do I report? Tomorrow, when the company grows bigger and they want, let us assume it is one share. Tomorrow if the company grows bigger and declares 100% dividend, 200, 500% dividend, those monies will only go to the resident shareholder, which they don't want. So, it is a challenge, no doubt about it. When you file an FCGPR, attach these forms 4, 5, at least form 5 and 6. 4 is given by the investor, 5 is given by the person whose name the shares are being held, and 6 is filed by the company. So 6 is, as an attachment to 6 we have 4 and 5. So in the FCGPR, you make out a covering letter and file form 5 and 6. The law actually FEMA does not recognize this. Right? Tomorrow, at a later point of time, when dividends are being declared, maybe by the time the company's management would have changed, maybe by the time the banker would have changed, so many things could have happened. When you want to repatriate dividends, when you say that FCGPs have been reported and this is how it is, there is a very big possibility of the banker accepting it, which we have done earlier. But if you don't file these forms, when the beneficial ownership is not, the point I am trying to communicate here is, FEMA does not recognize. So you need to communicate this to the controllers, to these regulators.
No, it does not recognize, but it doesn't bar also.
It does not bar, sir, but unless I report, the benefits will not accrue. Now, one thing is, we will copy கொடுப்பீங்க. நான் வரலன்னா எப்படி கொடுப்பீங்க? Very simple, la. நான் வந்த ஹால்ல வந்துட்டேன் சார் சொன்னா நீ காப்பி கொடுப்பீங்க. இல்லைன்னா வந்தா காப்பி கொடுக்கறதுன்னு சொல்லுவீங்க.
நாளே நிறைய கொடுக்க மாட்டாங்க.
So coming back to the sir, I beg to say, RBI these days, for several years I've seen, at least the last 4, 5 years or 6 years or even more, Chennai RBI has been very, very courteous, forthcoming, and they have been proactive. When you file a compounding application, many times I've got calls asking for clarification. They give you suggestions. Sir, change it like this and refile it, will approve. There's no need for them. They can summarily reject it. So RBI, I mean, prior to probably and FEMA days, I don't know how it was. Okay, in FEMA days, after I started practice, after I started going to RBI, I find RBI Chennai. I have not interacted with the outside other than I've spoken over phone, but I have not gone there. But as far as Chennai RBI is concerned, I am telling you, hats off to them. And irrespective of the people, officers who are there, officers keep changing. They are courteous, they are definitely forthcoming, definitely they are very proactive. Hats off to them. In fact, what I was told is, Bangalore ROC has told the AD bankers to file all the old pending cases, and AD banker told me that their RBI Bangalore, Karnataka is taking a lenient view on the old cases to close it. I don't know about Chennai, but Chennai, if you give a proper documentation, they are doing it. I mean, documents which are probably acceptable to them. And recently I handled a 2004 case. The FCGP had come, the FIRC was not there at all. I had to give them any KYC. I got the passport of the allottee there in Australia, got it notarized there. And the original came to India, came to Chennai, I filed. It was the FCGP was taken on record. And then we went on to file a compounding application. And then on we went to file an FCTRS. It was accepted. Sir, coming back to the topic. So, it, as rightly said, it does not prohibit, but it does not recognize. So how do I, because under the Companies Act it is permitted, and people want that. When it comes to reporting, it is not happening. We cannot go and tell the client, look, this is not possible practically. You can't go and tell the client that form cannot be filed. No, this cannot happen. People, no client is interested in knowing about the pain or the process. Very simple. You can take it from me. I was very closely working with a very big accounting firm. Believe it or not, 10:45 at night they called me and asked me for information. I said, maybe you, I mean, practically, personally I work with 7, 8 maximum. Not it. For them, they will have to roll out, they will have to complete it. So they are billing it on hourly basis, probably. So here the FEMA does not permit, but FEMA does not prohibit. So how do I do it? Because why should I do it? Why should this form be filed at all? Is because tomorrow when the dividend is declared, when the rights issue is given, the bonus issue is given, the company or the investor should not have problems, should not face challenges. Better do it now itself. Then how do I do it? Right? So this is one challenge that we are facing. Have this declaration done under the Companies Act. and ensure that you are filing, so that at a later point of time we may not have any challenges. Even then we will have to convince, because the practical issue that we have today is, in olden days or when e-bills was there, or when the physical filing was there, we used to have copies of the FCGPR file. We were able to download and say what was filed. But unfortunately today, we are not able to download, we only get a screenshot of the FEMA portal, of the filing. So in a screenshot, we will not even know what are the attachments there. When I send an SCGPR to my client, I need to send the screenshots to him, give the username, password, and also give the attachment as a separate attachment to the email. Not in the form, he is not able to download and see what attachments are happening. So there are cases where there have been challenges, where they are not able to access those money. The principal thing behind the whole beneficial interest is the money should have come from abroad. That is the thumb rule. If monies that come from abroad and one of the shares is being held, one or more shares are being held on a beneficial owner in some by a resident individual, reporting has to be done, because the benefits, corporate benefits accruing from those shares in terms of your dividend, bonus, rights, etc., will have to go only to the principal investor, who is the person who has invested the money. And how do I do this? This will have to form part of your FCGPR and ensure that we have copies of them, so that tomorrow when this corporate action, you will not have a problem. Any question? Yes, sir.
The Benami Act,
No, the Companies Act forbids. Sir, no, sir. The purpose of Companies Act is different. Sir, Benami, there you are talking about, you become the owner, it is registered in your name and all those things. Because I am not able to hold, so I am giving it to you. But here, I want a quorum to be there. I want it to be a 100% subsidiary. Right? I don't know what is the purpose of the Benami Act. But the purpose of Companies Act is very clear. Otherwise,
Benami Act, is worried about Transfer Property Act, worried about any other act.
Correct. But
when it is,
practically, we as company secretaries and maybe many of the channel volunteers will also vote for it. This is happening where declaration of beneficial interest, people are declaring and having this there. Maybe it is not covered under Benami Act because the values are maybe very minuscule. It is not immovable property. You are talking about shares. That could be the major difference. It is not, you are talking Benami property, it covers your immovable property and other things also. But we are talking about securities, which is transferable, which is a good under the Sale of Goods Act.
Because we recently had a Benami Act session. And
possible, sir, but it is
not. We are told it will be totally confiscated. It's not,
If it is asset of different nature, but the purpose here for which it is given, you are coming and declaring that I am holding the shares on his behalf. There is a declaration. You are transparent.
Transparency is not the point. It cannot be held as a point in Benami Act.
Under Benami Act, the purpose of the act is different, sir. Under the Companies Act, it is permitting you, and at your go telling the regulator, look, he is the shareholder and holding one share on his behalf. Under Benami Act, you don't go and tell that I am the Benami for him.
The government record shows both beneficial interest also. In Benami, it is not there. The government record doesn't have that.
Correct. I am holding. See, it's hidden. You are too wealthy, and so you want to park your money and just giving it to me. I say, as if I am the Benami, I am the owner, I keep it with me. Whenever you want, I will give it to you. But there, under the Companies Act,
even the Income Tax Act, where clubbing section comes, when you say I give it to some other day, but I will get the benefits. Then the income will not be assisted in the hands of the person who is quoted. It will be assisted in the hands of the person who has given it.
Sir,
so
let me admit, sir, I am not here to argue on the Income Tax Act because I should not be talking about Income Tax Act in this forum. I don't know Income Tax, that is something different. Okay, my friend will also watch first. Okay. Because we are all working together. No, that's okay. That's okay. Arguments are same, but the Benami Act and the Companies Act and FEMA, the purposes of these enactments are completely different. The purpose for which these are enacted are completely different. Under the Benami Act, if my understanding is correct, there is no disclosure. The intention is to cheat. The intention is a different intent. I'm sorry to use the word cheat. The intent is completely different there. Under the Companies Act, I'm making it and telling the government, telling the regulator, look, he is a holder, I'm just holding it for his sake. Something like holder in due course. When that law permits, FEMA is not prohibiting. But how do I report? Because if I don't do it now, so if you don't report now, later on you will have challenges. How to overcome that challenge is my problem. Today you will do. Today I will do everything. I will file FCCPR. I will probably go. Which I don't want. The work that you do, that's what I was taught. The work you do should be etched in the stone. It should be so hard. So how do I report? That is the challenge here. Any questions, sir? I'll be too happy.
If it is a 1% share is held by a non-resident, is that
Non-resident still, sir, you will not have a problem under the thing because both become repatriable. Because the investor is a non-repatriable share, the nominee is also not repatriable. Okay, you will have to report, but definitely there could be a question there.
Sir, the intention of concealing an actual owner, that is absent in your filing, ROC filing.
No, here it is there. In ROC filing it is there. I am going voluntarily disclosing that he is the owner, I am only holding it for beyond.
That's what, sir. Here, the concealing the actual owner is absent in your case.
No, under Benami Act it is absent.
Yeah.
Under the Companies Act it is happening.
Yeah. Therefore, it is exempt. It is not coming under Benami.
I come and tell you straight, this is what it is. I am transparent, that's what I said, I am transparent.
Concealing the actual owner.
Pardon me?
You could be a power holder instead of being the owner in the...
No, I need two people. I need to have two shareholders. The power of I cannot, you cannot hold the entire say and give me only the power to utter. No, that is not possible. I need to, otherwise it is not meeting. For me to have a meeting, I need two people on the stage to talk. Be it a general meeting, be it a board meeting, be it any meeting. I need that quorum, so I need two people. Sir, there is a completely different story, sir. We are only talking about we'll break for tea, sir, or we'll not continue. Sir, tea ready? Yeah. I want a break. Thank you, gentlemen. Yes, sir.